In view of the aforesaid facts and circumstances, we are of the opinion that the impugned order does not call for any interference. Writ petition is dismissed. Yes.
Item number 18. It is, my lord, my Lamek Khan is also appearing in this case. My lord. Can it be, my lord, taken up at 2:30 hours?
18, what is your prayer?
Actually, I want to upgrade it. Can it be taken up at 2:30, my lord?
Upgrade may not be possible. Why is the urgency?
Urgency is that, my lord, already I am going to retire in this month.
No, he has already been retired in 2020.
No, 20, that was, no, correct. But that was.
So
select-
whatever benefit will be
No,
getting,
no,
Mr.
no,
Mohanta will.
No, that is not correct. That's why I'm pointing out.
No, we know he's not.
Since
We know he's not correct.
No, since he has placed before your lordship, I was retired in the 2020. I challenged before this honorable court, and this honorable court allow me my petition, and he filed a writ appeal, and getting a stay order because I am now going to retire from my original retirement matter.
We can assure you, if you make out a case,
No,
then
that,
you will get all the benefits.
that's why, my lord, that is this matter was fixed before this, and particularly take this bench because, my lord, it cannot be taken up by case number 1.
We cannot assure hearing. There are many matters of 18, 17. We'll try. When, as per you, when is the date of the superannuation?
According to the single
No.
As per the judgment, we are going to in November 2020.
No.
26, 25,
November.
November.
No, already by this order of the single judge, he has already retired, even going by the order.
November 25.
My lord.
Today is what?
19.
20. You want to work for 10 days?
Not that, my lord, but ultimately, other thing also not been.
We'll try. But
My
it'll take some time.
I was retired in the 2020. I was challenged before this, this honorable court.
Which organization, Mr. Roy?
Food Corporation.
FCI.
He is a canteen boy, my lord. Not a big shot, my lord.
You are serving food to the Food Corporation of India.
My lord.
Canteen boy serves food
Yes, my lord. Served food.
to the
Then
Food
he was-
Corporation
he
of
was
India.
promoted to the
That's very
court, my
good.
lord.
Is the provider of your food, why have you dismissed him?
He
Is
is
the-
so retired.
Who's the Annadata, you or him?
No,
Is the
FCI.
Annadata? You should not.
Now I am out of employment. No, if possible, I'll take chance, my lord, 2:30. And non-land, my lord, another that may fix, my lord.
We'll try. Why
My-
2:30? But why 2:30?
No, if before that, I'll be happy. But
No, no.
2 o'clock, there is another division, means, my lord.
Oh,
There
so
is
you
no-
have errands everywhere.
No, another division only for one item, my lord.
Let us see.
My lord.
We'll try.
Well, there is one item number 8. Eight, by the last order, we were directed to file a written argument. It was heard by the bench decided by Honorable Justice Farhana. So we are directed to file only the bullet points that we were.
So let it come after 2 weeks. If it is richer, if it is before the same bench, it'll be good.
Yes, that's better.
Okay. But we'll not say anything. Okay.
Lord.
Can we say joint request?
Lord.
You're appearing.
Yes, Lord.
Okay. Mr. Roy, your name is not there in item 8.
No, I am recently
Heard,
engaged in this case.
Heard Sri P.K. Roy, Learned Senior Counsel, as well as Sri D. Sekia, the Learned Advocate General for the state. Full stop on a joint request. Matter is adjourned by 2 weeks.
Lord.
Deeply obliged.
What are you challenging, Mr. Roy?
My lord, the provisions of in the GMC Act by which, my lord, the schools, private schools is right to obtain state license. That's it.
Trade license.
Trade license to the schools.
May I please, Your Lordship? My lord, item 5 and 7 minute, I pray for little accommodation. I am not physically well, my lord, that's why
Okay.
next, after 2 weeks.
But
it-
these are all matters, we'll grant you accommodation, but next week. Okay, 5 and 7. Okay, Mr. Sharma?
Yes, Lord.
5 and separate order, huh? On a request made on behalf of the petitioner, matter is adjourned to be listed after a week. Okay,
Wait, please, Your Lordship. My lord, with consent of my learned friend, I
Hmm.
beg to mention item number 17.
1-7.
Yes, my lord, I also have a prayer for upgradation subject to your lordship's consideration.
Upgradation is not.
Or can I pray, my lord, this matter, your lordship may take it next Thursday, my lord. I have also taken the consent, alternative consent of my
Next
friend,
Thursday.
my lord.
Is it tagged to this particular bench? No.
No, my lord.
Then, okay, then next Thursday it is possible. Other side informed?
Yes, I have.
On a request made on behalf of the applicant, matter is adjourned to be listed on Thursday next. Please give the date, huh?
Briefly.
My lord, I pray for listing fresh motion, my lord.
When?
My lord, tomorrow, my lord.
Tomorrow, when did you file?
Or yesterday, ma'am. I got the number, ma'am.
Okay, you come tomorrow.
May it please your lordship, I beg to mention item number 15, lordship. Lordship, may adjourn the matter for the day, lordship.
18 matter, why are you mentioning?
Lordship, conducting council is not available today, lordship, due to personal difficulties.
Okay, 1 week, but we are not going to adjourn matters of 18. On a
Not
request
for
made
the
on
day.
behalf of the petitioner, matter is adjourned by a week. Yes,
May I please, Lordship, I beg to mention for item number 13. Senior is out of station, so matter may be adjourned for
who is
2
your
weeks.
senior?
A Hussain.
Okay, 15 matter, 25 matter. Hearing, 25 matter. Oh, hearing, 25 matter. This matter has been admitted. It's come forth in the hearing column. Okay, on a request for adjournment has been made on behalf of the petitioner. Para, list after 3 weeks.
Hi, Lord.
May I please, lordship, I beg to mention item number 12, kindly this matter is adjourned for today. Item 12.
On a request, 2 weeks, on a request made on behalf of the petitioner, matter is adjourned to be listed after 2 weeks. Is that
Yep.
print?
Interim may be continued.
Interim order passed earlier. Interim is there, it's an FT matter. Is it written, is it limited till today? Is the interim order limited till today?
No, no.
Then why is the requirement?
No, I think it's not necessary.
Not necessary. Our side was in Side of one. Item number 12. You are granted bail or what? Bail, then where is the requirement to extend? No requirement. About it.
Should be allowed to be bail on disposal of.
Yeah, usually. Not to the from
Biometrics,
Not
5,000.
Not required.
It's on bail.
May I please, your lordship, I beg to mention item number 11, lordship, kindly adjourn for 3 weeks, lordship. Yesterday I was given adjournment.
You're for the petitioner.
Yes, lordship.
On a request made on behalf of the petitioner, matter is adjourned to be listed after 3 weeks.
May I please, your lordship, I beg to mention item number 10, my lord.
10 years.
Sir, M.U. Ahmed is out of station, my lord, so kindly. It
Okay.
can be may, my lord, on Monday or.
Not Monday. These are new matters. After 2 weeks, on a request made on 2 weeks.
Not sure.
There are matters of 17, 18. Yeah, motion है तो motion नहीं
Admission.
No, there is a partner matter yesterday. We said they will take up that matter first. What is number 1? What is 1?
Preventive detention matter, my lord.
What kind of preventive detention?
My lord, under PIT and DPS, my lord.
No, we'll have the partner first. Then we'll have the PA. Item number 1. Where is Mr. Pine?
Yes, proceed, please come in. All the time like go. Item not list. I'm gonna be supplementary. আপনার কি মাত্র কোনো আছে কি? আমি তো রিপ্লাই দিই।
Yes. It's 44 is a mistake.
Hamza.
Yes, suppose the পাইছে না তো আপনি কোড কপি আছে কি করেন
Yes, Mr.
Yes. My lord, your lordship has already seen, my lord, the discrepancies in age of the petitioners and projected brother and mothers, my lord. The discrepancies are huge discrepancies, my lord. And no prudent person can believe that mother and the same son will be of the same age in a particular year, my lord. My lord, no prudent person can believe that mother and the son will be of the same age. Because in 1970 voter list,
This submission is in the context of which document?
1970 voter list.
Page 1970.
Yes, my lord.
70 is at page
26, my lord.
27.
27 is the vernacular.
Yes.
Because as per the WS as well as evidence, my lord, this Ansar Ali Sheikh is the brother of the petitioner. And Chandraban Bibi is the mother. So it cannot be accepted at all, my lord.
It's not a projected case also, I think that at this time, it was made, the stepmother, the projected stepmother expired.
Expert.
Otherwise, her name should not have been reflected.
Her name was not reflected here, not reflected here. But in fact, he has, in WS said, everybody expired. Mother expired, father expired, brothers expired, my lord. This is one another aspect. And when expired, no mention at all. Because this is very important. The brothers, projected brothers, my lord, their age difference is very much, age differences are there. And in 1951, the NRC, the petitioner is not there, projected brothers were there. That is the only document where the entire family was there. My lord, their case was, it was not their case that this Ansar Ali Sheikh is stepbrother. It was not their case in any stage prior to the filing of this writ petition. Because neither it is stated in the evidence, nor is stated in the WS. Well, it was not a projected case that the Ansar Ali is his stepbrother. This has afterthought, this is an afterthought story. While filing this writ petition, this has been developed. That's why this document is very important. Now, my submission is, my lord, if they rely on this document that this Chandraban Bibi is his mother and Ansar Ali Sheikh is his brother, and if they say the age discrepancies may be ignored. Only this part may be relied, that part may be ignored. That cannot be. The document has to be relied in full, not in part. If they rely this document, they have to rely it fully. If they want to ignore this, not to rely this document, they have to ignore it fully, not in part. That is settled position of law. That is, there is no ambiguity on that matter. Similar is the case in 1977 voter list also, my lord, where the projected murder and the petitioner is there. And there the age difference is only 10 years. Page 29, my lord. There the age difference is only 10 years because Chandraban Beba, she was 35 years as per the 1977 voter list. And this my lord, Amjad Ali project.
Amjad Ali is the petitioner.
Petitioner, my lord. Petitioner is of 25 years. So their age difference is only 10 years. Even this, my lord, this is also for a prudent person. It's not acceptable that a person, a lady, will give birth at the age of 10 years. Because if this is true, my lord, then it has to be accepted. She was born when the mother was only 10 years. The petitioner was born when the mother was only 10 years. For a prudent person, my lord, can it be accepted? So my submission is it cannot be accepted. No prudent person can accept it as a valid one. Another aspect, same thing, my lord. If he is relying on these documents, he has to rely fully. He cannot say this, my lord, the other part, the relationship column, Chandrabanu Beba, wife of Rahim Box, and Amjad Ali, son of Rahim Box, may be accepted. And the, my lord, the discrepancies, where age discrepancies, that may not be, that may be ignored. That cannot be done. If you want to rely his document, he has to rely fully, not in part. That is the settled position of law. So that is the point, madam. So only these documents are there. These two documents. Other documents are, my lord, neither helping the petitioner nor helping the mother. So discrepancies in these two documents, 1970 and 1977 document, and my lord, story projected in the WSN evidence is fully contradictory. And it's not believable at all. Story projected there, my lord, that my lord, the Ansar Ali Sheikh, his brother, this document, my lord, says it cannot be accepted at all. 1970. Of course, here in this petition, they are saying this Ansar Ali Sheikh, his stepbrother. This was not a pleaded case at all, my lord.
This was not a pleaded case.
Pleaded case at all.
Before the tribunal.
Before the tribunal. That's why nothing is there in
Only
the
the
opinion.
handwritten part has mentioned about.
Handwritten part, that there it is said the mother, stepmother is there.
Stepmother.
But yes, but not said that it's Ansar Ali Sheikh, his stepbrother.
The son of that
Yes, that
lady.
that is also no. So simply he has said it. I have 4 brothers. Ansar Ali is one of that brother. So if Ansar Ali is his brother, as projected in the WSN evidence, so it cannot be accepted at all that Chandraban Bibi can be mother of Ansar Ali. The tribunal has committed no wrong in that aspect. To that effect, my lord, the numbers of judgments are there. The document has to be appreciated all. Appreciated in full. It is 2013 1 GLT. Sorry. This is WPC 1002 2016. 1006.
006
Yes.
of
2016, my lord. This is
Name?
reported 2018 1 GLT 372, my lord. 2018 1 GLT 372.
Name?
Name Basiron Bibi. Basiron Basiron Bibi 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 versus Union of India.
Which paragraph?
Paragraph 1330, my lord.
30.
Yes. There earlier, my lord, these discrepancies, the voter list were accepted at a whole. There was a judgment of Abdul Matali, and that has been, my lord, in this judgment, that has been clarified. my lord. Reliance is placed in this case, in the case of Abdul Matali, areas so and so, can be no assistance to the petitioner in as much as it has already been clarified by this court in previous decisions that said decision did not lay down any law and was decision confined to the facts and circumstances of the case, particular case. Now, madam, this partition regarding discrepancies in the voter list. Regarding discrepancies in the voter list, which the petitioner contended were not her creation, being entered into the official election commission and therefore should not be used adversely against the petitioner, such contention is without any substance. The voter lists were adduced as evidence by the petitioner herself to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only that portions of the voter list which are in her favor should be accepted and those portions going against her should be overlooked. This is not how a documents put forward as a piece of evidence should be examined. The document has to be appreciated as a whole. That is the point here, my lord. So my submission is that, my lord, if these two voter lists are ignored or this cannot be accepted as a valid piece of evidence, there is no other documents to link the petitioner either to Rahim Baksh Sikh or to Chandrabhan Bibi or to, my lord, the projected grandfather Khudu Sarkar or Khuju Sikh. That is one point, my lord, on merit. Another aspect, my lord, my learned senior friend has argued that, my lord, the tribunal has cross-examined and he acted as a prosecutor. In fact, my submission is that, my lord, if your lordship may kindly see, in the record also, it's in the top, it is written query by tribunal. So query under 165 is permitted. Because it is
165 queries.
yes, 165 Evidence Act queries, it is permitted.
And all court can do.
Yes,
Every court can do that.
every court has tried that under 165 Evidence Act. Now, my lord, there is no bar in under 165. If we see the language of 165, there is no bar. Any question, anything he can ask. Only bar is that, my lord, he cannot insist the witness to give the answer if the witness don't want to give the answer. He cannot insist. Whether it is relevant or irrelevant, any question the tribunal can ask, or the court can ask, my lord, for the proper funding of the facts. So that is the position here.
65 queries, can it be labeled as cross-examination?
No, it cannot be
No,
leveled.
it's-
It is
it's
not
like-
procedure.
Like a court
That-
witness, court examination.
Court can examine, my lord. In fact, here the tribunal has said it is a query by tribunal. It's in the page 65 itself, it is said. And the statement which we see, it is not in the nature of cross-examination. He just wanted to know some facts. So those were clarified by what fact. So this is not a cross-examination. And there are numbers of judgment I have, my lord, and my lord, in that aspect also, another aspect in this line also, my lord, even though the queries were made by the tribunal tribunal has not considered this while passing the opinion. Had it been considered, my lord, then also it could have been said that yes, tribunal had the my lord, discretion to consider it or not to consider, but tribunal did not consider it. So it is no way these questions prejudice the petitioner, my lord. If your lordship see the opinion tribunal has not considered these my lord queries. So it has no way but prejudice the petitioner, my lord. Even though it is asked, it was a query put by the tribunal for satisfaction. However, while passing the opinion, he did not consider this. So by any means, it is my lord prejudice to the petitioner. Another aspect, my lord, which my learned friend argued yesterday, senior friend argued yesterday, my lord, that the, my lord, the evidence of DW2 and the evidence of DW3 were not considered. In fact, my lord, if your lordship can see the opinion, my lord, it cannot be said that it was not considered at all. The DW2, DW3 has been discussed in the first para itself, second para of the opinion, my lord. No, my lord, page 69, my lord. Decision, discussion, and results thereof. Page 69, my lord. Page 69, last para, my lord. I have carefully perused the case record along with the evidence of DW1, DW2, cousin brother, and summoning witness DW3, officers of the settlement office. So it is not that they were not considered. Along with the exhibited documents, OPDW1 Amjad Ali in his evidence inter alia deposed that he is citizen of India. Then, my lord, going on after in page 70, the DW2 is discussed. After fifth line from the top at page 70, my lord.
Yes.
DW2, after Hussein, son of late Jabbar Ali Sheikh, cousin brother of the OP, in his evidence inter alia, deposed that DW2 is a genuine voter since the year of 1978 village Sakalpura under 32 South Salmora LAC, having voter ID card, and the OP is his cousin brother. DW deposed that his DW's father's name, Abdul Jabbar Sheikh, alias Jabbar Ali Sheikh, who is the elder brother of the Rahim Box, father of Soinchu. DW2 further deposed due to erosion of river, his parents, including himself, shifted to the village Soinchu. So DW3 was also, my lord, considered. DW3, someone witnessed Kamal Kumar Roy, office assistant of the settlement officer Thuguri, in his evidence inter alia deposed that the final Khatian register book recorded the name of so-and-so. So all these things were considered. Now, my lord, page 72, the finding, last part of the opinion, my lord. Page 72, second paragraph. From the above discussions on exhibits as well as on evidence on record, so everything is considered. OP has failed to establish his link with the either parents whom he claims to be his father and mother as projected. This is the finding. So it is not that the brother's evidence, my lord, the evidence of DW3, the evidence of DW1 was not considered. My lord, with regard to this, my lord, it is, the statute says, my lord, I have, the tribunal gives opinion. It's not an order. It's not an judgment. So it may not contain each and every details of the facts and circumstances. Here it is said, my lord, the opinion must contain the conscious concise facts of the case and a decision thereof, conclusion thereof. It may not contain each and everything here. Okay, my lord, one judgment of this honorable court. This is in fact, my lord, 7339/2015. 7339/2015. Amina Khatun. Musammat Amina Khatun. 7339 of 2015. ma'am. This is decided on 19/4/2018. The original issue was here, my lord, whether the res judicata will apply or not.
Decided on?
Decided on 19/4/2018. Therein,
Judicata doesn't apply,
my lord,
does not apply.
yes, res judicata, in this judgment, it is said it will not apply.
Really?
Res judicata will not apply. But it was later on in the Supreme Court said, my lord, it will apply.
Yeah.
Res judicata will apply. However, I am not on that, my lord. Only one para of this page, my lord. It's page 40, para 44 of this judgment, my lord. Para 44 of this judgment, what said? Just I'm reading that part on it.
Please.
slowly. Yes,
Para 4.
para 44, my lord.
44.
Do you have that Supreme Court judgment by any chance?
My lord,
Where that Supreme Court judgment which overturned our division bench judgment?
that is, my
Regarding
lord,
the issue.
Abdul Quddus.
Abdul Quddus.
Abdul Quddus.
Abdul Quddus. That was in different prospect, my lord. It is said. However, it is accepted because here it was especially with regard to the foreigners tribunal cases. This foreigners tribunal cases pending in the foreigners tribunal.
Right.
Whether res judicata will apply in that case or not. And Abdul Quddus was somewhat different,
It was not pertaining to FT.
but exactly not in this context.
This Abdul Quddus, we had discussed in details in the full bench,
Yes,
that those matters for transfer,
yes, transfer.
because this was also one of the issues.
Yes,
Do you have the judgment? Is it reported?
this judgment is
No,
prior.
no,
to
no. Full bench.
Full bench judgment is it is reported, my lord. It is.
There is a
reported.
discussion on Abdul Quddus.
Yes, yes.
If you have the full bench, kindly.
I will get it, my lord. I will get it. But this is not on that, my lord. This is only for the purpose. What?
No, understood, but
Yes.
since that thing
Yes,
has
yes, yes,
arisen just for our,
yes, yes. There
discussion.
there is a full bench judgment of this. I'm reading slowly, my lord. We'll get. From the above, para 44, from the above, what is evident is that foreigners tribunal renders an opinion on the reference made to it, and the opinion shall comprise of concise statement of facts and conclusion. The opinion should comprise of concise statement of facts and conclusion. This, however, does not mean that the opinion rendered should contain only concise statement of facts and conclusion briefed of any reasoning. It is simply that there has to be some reasoning connecting the statement of facts to the conclusion, though such reason need not be elaborate considering the summary nature of the proceeding. So it need not be elaborate, madam. That is the point which I want to bring. Because it is a summary nature. The proceeding is a summary nature. So here in the tribunal in this opinion, my lord, has discussed the facts, given his, my lord, opinion, which conclusion. So it is not that everything he has to discuss elaborately, my lord. That is the point here, what I want to place before your lordship. So if other, my lord, discrepancies in age, my learned senior friend was arguing the discrepancies in age may not, my lord, fatal to the proceeding. In case of the proceeding, but it is, as I have already pressed the judgment of this honorable court, my lord, where it is said, but mere saying that my age is so and so is a different thing, but it is recorded and they relied on those documents. That's why I'm saying if they are relying on that document, that has to be fully regularized. So there it is discrepancies part may be ignored and which are consistent, those may be accepted. That is not accepted. And another aspect, my lord, in the same line, because if your lordship may kindly see 1970 voter list, who are there, and 1977, who are there. Because it is very important, my lord. My learned senior friend will, has argued also that these are minor discrepancies. 1977, it is 35 years. 1977, only voters are Chandrabhan Beba and Amjad Ali. My lord. And 1970, only voters are 1970, only voters are Rohim Bok Sheikh, Chandrabhan Bibi, Ansar Ali Sheikh. Now, the discrepancies, to accept this, to overcome these discrepancies, my lord, if these discrepancies could be, my lord, ignored, had there been other persons' names and they were consistent, their age were consistent. Other persons like grandfather, other brothers of the project, the petitioners projected brothers, if their names were there in the same voter list and their, my lord, ages were consistent and names were consistent, then it could be accepted, yes, it can be a typical error. It's a single typical error, or it can be a minor mistake. But if other names are not there, if we cannot compare with the other persons who were there prior to 1971, in 1951 NRC, my lord, we cannot say these persons and that person, those are of same persons. That is what, my lord, Kepatullah and the Honorable Supreme Court says in this case, Sirajul Haq also. In Sirajul Haq, Supreme Court says, yes, minor discrepancies can be ignored. This is, my lord, 2019 5 SCC 534. 2019 5 SCC 534. I'm just reading para 3 of that small judgment, my lord. Para
By
3.
Justice Nariman.
Yes.
Hmm.
Nariman judgment. The discrepancies there, my lord, said that if minor discrepancies may be ignored in these cases, there is no doubt that, para 3, my lord, there is no doubt that great grandfather's name Amatullah appears as Amatullah throughout the document. Equally, there is no doubt about the father's name, which appears as Hakim Ali throughout. The only discrepancies found in the name is in the document is Kefatullah,
And Kemal.
later become Kematullah. However, what is important to notice that father's name Amatullah continues as Amatullah and other family members associated continued as such. My submission is, my lord, had there been other persons who are continued in the same voter list, and there is discrepancy in the
We have discussed this.
yes, in
Case
different
of Sirajul Haq in many
yes,
cases.
many cases your lordship has
And the inconsistency, discrepancy which was noted
yes,
by the Honorable Supreme Court, that was an appeal
yes,
by the proceeding,
yes, my lord.
because that was set aside, and said that this discrepancy is minor because the other aspects are consistent.
consistent.
Only for the name of one, instead of Kematullah, it became Kafatullah.
Yes,
Grandfather, father were consistent.
yes. That's why I'm saying if there is this one mistake in the entire voter list, in the entire family, And that can be accepted as a minor discrepancy. But entire voter list is, if the discrepancies are in the entire voter list, ages of all the persons, names of all the person, how can we say that it is a minor discrepancy? It cannot be accepted as a minor discrepancy. So under such circumstances, my lord, my submission is that tribunal has committed no wrong while declaring the petitioner to be foreigner. The other aspects I have already submitted yesterday, my lord, that the
This Sirajul is 2019 5 SSC, 534 or 594?
2019 5 SCC 534, 534. And it is, my lord, settled position of law also, my lord, what they have pleaded in the WS, that has to be proved in the evidence. They cannot traverse beyond the, my lord, pleading. Beyond pleading, they cannot prove. That is settled position. So that is my submission, my lord. It may not be interfered under certiorari jurisdiction. Obliged.
May I please?
Yes, sir. Short rejoinder, we have heard you extensively. Short rejoinder.
My lord. I have to some clarification, my lord.
Yes,
that-
please.
Regarding my lord, handwriting portion, the mother's name, my lord, petitioner's mother's name.
Yes.
Two mothers are there, stepmother and his biological mother. My lord, in that point, the learned member has cross-examined in that line. So he has answered, my lord, kindly see the cross-examination of DW1, page 56. Type to. My lord, my father died after 1970.
Page?
Page 56.
5-6.
56. Cross-examination of DW1.
Yes, please.
I was born in village Talakura, Shialmari. Grandfather's name is Khudu Sheikh. The grandmother's name is Hausi Bibi. Mother's name is Chandraban and my stepmother's name is Gulejan Nesa. So, my lord, he has stated in cross-examination, his stepmother's name is Gulejan Nesa. So, now, my lord, in the
Now, is
WS,
there a question put in the cross-examination with regard to the insertion by hand?
my lord, that question, my lord, when it is placed before the evidence as well as WS. So, on the basis of evidence and WS, on the basis
Mr.
of
Ray,
that,
please answer the question.
my lord.
Is there any question put with regard to the handwritten portion? Why was it?
No, my
Then-
lord. No, my lord. So that person is not questioned. So, my lord, perhaps he was asked what is your mother's name. That's what the answer comes. My mother's name is Chandraban and my stepmother's name is Gulajan Nesa. So, my lord, regarding that portion, my lord, in the judgment also, in the judgment opinion also, my lord, it is written by the tribunal. Page 69. Last portion, last two lines. Father's name is Rahim Baksha, mother's name is Chandraban Bibi, and stepmother's name is Gulajan Nesa. So, my lord, it is clear that
Page?
page 69. First two lines, my lord.
Sixty-nine. Page, which
Page
one?
69, my lord.
Which-
69,
Yes.
69. So, my lord, as it is clear, my lord, that Gulajan Bibi or Gulajan Nessa is the stepmother. So, my lord, regarding voter list, Ansar Ali and Shorban, Chandrabanu. Chandrabanu cannot be the mother of Ansar Ali Sheikh. My lord, it is clear that Chandraban Bibi or Chandraban Bewa and Gulejan Nessa, two wives, stepmother and mother. So the age difference in voter list 1970, comparing Chandraban Nessa and one Chandraban Bibi and Ansar Sheikh, my lord, they are not mother and son, my lord. And my submission is that the Ansar Ali Sheikh is not the son of Chandraban. Otherwise, my lord, mother says 29, son says 20. It is impossible, my lord. It is not possible. Practically, it is not possible. That's my lord, where others' mother, stepmother's name is clear. So, my lord, in the cross-examination also, the learned member has not asked about what about Ansar Ali Sheikh, whether he is the son of Chandraban Bibi or Gulajan Nessa. That was not clarified. So, my lord, it can be, my lord, it is possible that Chandraban Nessa is not the mother of Ansar Ali Sheikh. And, my lord, next, discrepancy of age, my lord, regarding age in a Jalil
10 years.
Jalil Haq, my lord. Jalil Haq's case.
Is it reported?
My lord, no, my lord, it is not reported. Supreme today, my lord, I have got. Paragraph 10 and 15.
Five eight nine eight. 19. Order dated?
Order dated 14/6/2022.
Name?
Name, my lord,
Not
Jilal Haq versus Union of India.
Which para?
Paragraph 10 and paragraph 15. In paragraph 10, my lord, line about three line, my lord, third line. Further, at the right side, my lord, see, I'm reading the paragraph 10. The learned
No, we
tribunal
have read
observed
this. This is not the finding. Where is the finding?
findings, my lord. The further, the age of Hussein Ali in the voter list of 1966 is recorded as 23 years, in which event he ought to have been about 50 years when his name was listed in the year 1993. But it was shown as 81 years, and as such, this huge difference of age cannot be ignored. Learned tribunal also observed that the deposition of the petitioner was silent and as regards the discrepancies. Now comes to the finding by lord, paragraph 15. This discrepancies arose, question arose, now finding. Further, as regards the discrepancy of the age of the said Hussein Ali in the voter list of 1966 and 1993, it is now acknowledged that the age in the voter list is not accurate and the mistakes often occur due to wrong entry in the enumerator by the enumerators or because of incorrect information furnished at the time of enumeration, and as such, mere discrepancy in the age cannot be a ground to disbelieve the genuineness of the plea of the proceeding unless it is proved that the voter list is not genuine or fabricated, which is not the case in the present case. So, my lord, this petitioner has submitted the certified copies of the voter list, my lord. He has nothing to do about the record put there, my lord. So, if the election branch has committed the mistake, my lord, and for that, my lord, petitioners should not be suffered. And it is this clarified by this judgment that if the certificate, the voter list is genuine, the age difference or mistakes committed by the other side should not suffer, my lord. Then, my lord, in a Supreme Court decision, Rohim Ali, my lord, Rohim Ali's case, paragraph 41. Paragraph 41, my lord. May I read, my lord? The evidence before the tribunal by the appellant to indicate that his parents had resident in India much prior to 1166, whereas his siblings and he himself much prior to 1971 has been disbelieved only on the ground of mismatch of actual English spelling of the names and discrepancy in dates. As far the discrepancies in dates and spellings are concerned, we are of the view that the same are minor in nature. Variation in name, spelling is not a foreign phenomenon in preparation of the electoral roll. Further, the electoral roll has no acceptance in the eyes of law insofar as proof of date of birth is concerned. A casual entry by the enumerators when noting and entering the names and dates of births and also the addresses of the persons while making preparatory surveys for the purposes of preparing the electoral rolls cannot visit the appellant with dire consequences. So, my lord, Supreme Court also clarified that mistakes committed by the enumerators, my lord. And if your lordship gone through the voter list of 1985, 85 voter list, the age is tally with the son. They have disputed age between mother and petitioner, Sonroban Bibu and the petitioner. So in 85 voter list, this is also certified copy, my lord. This age is tallied with each other. 85 voter list, page 32, my lord. 32? Page? Yes, page 32. In paragraph 44 of the Rohim Ali's case, my lord, it is paragraph 44 of the Rohim Ali's case, my lord, overall discussion. Paragraph 44. from all overall discussions on the report opinion of the tribunal dated 2017, it is clear that there are minor discrepancies in the appellant's documents. However,
What are the discrepancies here in that case?
my lord,
It is-
regarding age, voter list,
Let us
age,
see,
name,
let us see what is held to be minor. Where do you get?
my lord, minor discrepancy.
Into factual fact.
In the facts, what is the minor discrepancy?
Age discrepancy is there, my lord.
Where?
My lord, I am there. My lord, paragraph 9 starts from paragraph 9.
Yes, please.
This is discussing, my lord. Paragraph 9. It was submitted in last portion, my lord, in page, paragraph 9. And they submitted the subject to unfair treatment of the tribunal, appearance and official personality. Notation. Further, it was submitted that even the High Court in the impugned judgment has gone to technicalities by accepting minor
Not this,
discrepancies.
Mr.
My lord,
They,
my
just
lord,
like in the other case, Kafatullah has been specifically mentioned. It's held to be minor. In this case,
No.
what has been held to be minor?
my lord, all the, my lord, discrepancies, total regarding, total discrepancies of age.
Mr. Day, we have to consider the judgments in the facts of the case.
My lord,
Has anything discussion been made on the facts that this is the discrepancy which we hold to be minor, just like the Kafatullah case?
my lord,
Kafatullah, grandfather's name was consistent, father's name was consistent in one name. Instead of Kamatullah, it became Kafatullah. Honorable Supreme Court said that no, this
my lord.
should have been ignored. Here, is there any discussion?
Yes, my lord, age and names discussions.
Where?
are there. My lord, I, this is a long journey, my lord. That's why, my lord, it is discussed regarding age and the name discrepancies of name, date of birth, etc. Main grounds. My lord, paragraph 41, whatever I have read, my lord, it is mentioned in this paragraph. Discrepancies of name and age.
No,
Date.
what is the discrepancy? Let us understand. What is the age discrepancy? What is the name discrepancy?
Yeah, 41. Actual spelling is.
41, my lord. Regarding discussions, my lord, age and date of birth, the discussion is paragraph 41.
So there is no name. How is it a minor discrepancy of age or name? We do not know.
But in that line, my lord, I am submitting that
No, no.
regarding discrepancies of the age.
I've
and date.
understood. So what is a minor discrepancy? What is a major discrepancy? unless the names are specified.
My lord, in a Jilal Hawk's case is clear, my lord. Jilal Hawk's case is clear. 31 is here is the age difference is about 31 years, my lord. 20 recorded 23 years and the 50 years. So about 31 years difference of age. 93 should be 50 years, but it is recorded 81 years. So there is a, my lord, big discrepancy. So it is in this case, paragraph 15, my lord, it was held on Jilal Hawk's case.
Mr. Ryan, we are just on this issue. Is there any mention of the names or age in Rohim?
My lord, so far I read my lord 2-3 times Rahim Ali. I have not seen. I have not
It
seen.
may be there, but it is strange that when you come to a finding, there has to be a consideration, discussion. on
It
the
is
fact-
only on the submission of the my lord, the appellants. That is based on the submission of the appellant. What I understood, my lord. That is based on.
No, in all cases,
Yes,
not
discrepancies.
to talk about Jilal, how gets a high court judgment, even in the Kamatullah, Kafatullah,
This,
there is a specific
yes, my lord.
comparison of the
Yes.
names vis-a-vis the discussions, what has happened to the grandfather, what has happened to the father, those appears to be consistent, and therefore this appears to be a mere
It's a statement, my lord. Here-
error which can be ignored.
Yes.
So only then you can come to a finding, but here the finding is based on which discussion?
It's finding on my lord presumption, my lord. What I have seen, with all respect to the Honorable Apex Court, my lord. The finding, this para 41 is on presumption, my lord. Presumption that the voter list, commonly it is the enumerators commit mistake. In fact, without hearing the my lord other side properly, with whether my lord, the entire voter list can be discarded in that way. The voter list, its mistake is there. That presumption cannot be drawn.
Honorable Supreme Court judgment, you have to.
No. That is.
No,
with
that is
respect
the
to-
principle we have to, principle we have to follow, but principle based on which facts? Facts cannot be ignored. Okay.
Only one
That's
thing
all?
I would like to point out, madam, nothing, here in the record, my learned senior friend has written, I have seen that, madam. Well, the translating the cross part, madam. He has written it is cross examination by. Madam, the cross examination by court or tribunal. In fact, that was not the original version. And that may be corrected, otherwise it may go in a negative manner, madam. If your lordship may kindly say page 56.
Queries by the court,
Yes, queries page 56, they have translated as cross by DW.
queries by tribunal,
Yes. That should be, my lord.
left hand top corner.
Page 57, it is queries by tribunal. But in page 56, while typing out, they have said translated copy cross of DW1.
Why is this?
This may not be, my lord.
Mr. Day, why have you done this?
My lord,
Page 57 and 56. From where do you get this cross of DW1?
query of tribunal.
No, in 56, where have you written query? You have written cross of DW1.
It's the usual format, but it is query by the tribunal.
AJP was absent, my lord.
No, while you have transcribed, typed out, why have you written cross of DW1? Where do you get cross of DW1?
My lord,
Where is the expression cross of DW1?
query by tribunal, thereafter cross has been given.
You have
Cross.
you have to put the cross sign. You cannot
No, my
write
lord.
cross.
That I have not put this cross.
Then who has been at page
In
56?
the page 57, kindly see. my
Kindly
lord.
come to page 56.
Source is there.
Page 56. What have you
Oh,
written?
my lord, that is.
That we are trying to. And we have not written queries by the tribunal.
My lord, query by tribunal, kindly see, below query by tribunal, this cross is given. So
You have to
it is
put.
presumed that it is.
No, not. It's
it
not
is
like
cross.
that. If you
Cross.
transcribe, if you have to transcribe, it has
And
to be the exact copy.
Otherwise also, my lord, query by the tribunal is binding himself to consider that.
We are not on those aspects. While you transcribe a document, you cannot introduce something of your own.
That I can.
So where is the expression queries by the tribunal in your type copy?
My lord, sorry, my lord, it is not written.
Not there, you have not written.
It should be, my lord, query by tribunal. It should,
You have written cross of tribunal.
it should be.
Court or tribunal
Yes, yes.
would not conduct
My
courts because it cross on behalf of whom?
Yes.
Court is neutral. So queries,
Queries.
better understanding of the case. And Mr.
But-
Pine, as far as you said that infirmity, which we've said, of course, this is very fair that minor infirmities should be
Yes.
overlooked, but an infirmity will not be considered minor. It's an obvious thing actually. If the infirmity is of such a nature that it throws doubt on the linkage and the document itself.
It is under section 165 evidence and not, my lord, that is put queries for clarification, some documents or a query. But here is the lengthy, my lord, questions, lengthy questions. All, and
To that
all
effect-
aspects is covered up.
To that effect, I have numbers
So
of
that
judgment.
cannot be a query, my lord.
I have brought numbers of judgment to that effect, man. If you are.
And my lord, in this regard, my lord, that query made by the tribunal, my lord, is binding upon himself to consider that aspect. That is, my lord, it is given in Johura Khatun's case, my lord, paragraph 4. He is duty bound to consider.
Yes, okay. That's all?
My lord, other replies, my lord, that is,
That full bench judgment. Full bench judgment is given.
Yes, yes. Okay. You need not, there's no necessity to take out. Where is that discussion? We have to discuss that part also.
my lord, in Hyder Ali's case, my lord, my learned friend raised two questions here that date of birth is not mentioned and the relative's name is not mentioned. My lord, in Hyder Ali's case, my lord, paragraph 24. Paragraph 24, my lord, it is held that the mentioning of date of birth in the WS is not mandatory, my lord.
Paragraph?
Paragraph 24, my lord. Paragraph 24, that, my lord, mentioning of other relatives' name is not mandatory. No, paragraph 42. Paragraph 42, my lord. Paragraph 42, my lord. On the proper analysis of the aforesaid observation made in the Sarbananda Sonal's case, my lord, following aspect emerged. In order to establish one's citizenship, normally he may required to give evidence of his date of birth, place of birth, name of his parents, place of birth, and citizenship. However, the Supreme Court nowhere states that the aforesaid facts must be proved only by documents. The expression used is normally, he may be required to give evidence. Thus, it is not mandatory to prove all these to show that he is an Indian citizen. This is not mandatory, but he has stated, petitioner has stated that he was born and brought up in this Charakula village, my lord. So another portion, my lord, in 24 paragraph, that the relatives' names is not mentioned in the WS, that is Ansar Ali Sheikh or his cousin brother, my lord. My lord, these are not actually non-mentioning, it is clearly stated, my lord, that the non-mentioning of his other relatives as well as that of his fathers cannot be a ground to disbelieving the testimony of the documents relied by the petitioner. So in paragraph 24, my lord, it is clarified.
No, paragraph 42.
That
of-
is
of-
non-mentioning of
No, last
date of birth.
line, last line. Please read again. In order to establish one's citizenship, normally here,
normally he may be required to give evidence of date of his date of birth, place of birth, name of his parents, their place of birth. These are all mentioned except date of birth in my WS. They all are mentioned. The citizenship. However, the Supreme Court nowhere states that the aforesaid facts must be proved only by documents. The expression used is normally he may be required to give evidence. Thus, it is not mandatory to prove all these to show that he is an Indian citizen. It is not
these are,
mandatory to prove
please read again.
all this.
Please read again. It's not the end. These are, however, relevant facts. If one proves can establish beyond doubt that he is a citizen of this country, yet he may be able to prove his citizenship by other evidences as well.
That's the point.
Merit.
So you cannot,
Other evidence.
without reducing evidence, you cannot say that you are a citizen.
Other evidence.
There has to be.
Other evidence means, my lord, if date of mention is not, my village name is mentioned, then relatives name is mentioned. These are all should be considered, my lord, on record.
I think you've replied everything which Mr. Payang has argued. Anything left out?
My lord, regarding my lord, that Johra case regarding him, my learned friend had submitted lastly, my lord, that DW2 evidence that the London Foreigners Tribunal has considered the queries made in the opinion, my lord. But actually, my lord, his queries has not been considered in the opinion. Queries made to DW1, DW2.
By the court,
By the court.
by the tribunal.
It was the duty of the tribunal to consider that aspect of the
Okay.
Johra's case.
Judgment is of court. Who, what of you be appearing? And Kolita. For AILE. Again, so I can do my thing, hold this one up. We'll consider and reserve, we have reserved the judgment. okay?
Yes. Obliged.
Item one, yes.
May I please, your lordship?
Wait. Yes,
My lord, preventive detention matter, my lord, registered under PIT NDPS, my lord. Under section 3(1), my lord. Detention order is at page number 15, my lord, of my writ petition.
yes.
Advisory board confirmed the detention order for 1 year, my lord. Out of 1 year, it's 173 days, almost 6 months gone, my lord. Lordship will come to page number 15. My lord, detention order, para 3, my lord.
Page 15.
Page 15, para 3, my lord. Whereas on perusal police report and connected reports, it appears that the said accused has persistently involved himself with the crime of illegal business of narcotic drugs since many years and was arrested in the following cases. My lord, 2 cases were relied. And my lord, that word, my lord, that perusal of police report and connected reports, my lord, includes FIR, forwarding Caesar list. And my lord, most vital documents, my lord, statements of accused, my lord, because in both the cases, my lord, the detainee was arrested based on the confessional statement made by the prime accused. Nothing was seized, recovered from his practical possession. So it was based on the confessional statement made by the prime accused. So statements plays a vital role here, my lord, in this detention order, my lord. And when detention authority arrived at subjective satisfaction, my lord, to pass this detention order, they must have gone through the statements made by the prime accused. Here in this case, my lord will find that, my lord, in the records, my lord, I have annexed that, my lord, that the documents which were relied, my lord, were totally incomplete, my lord. And incomplete documents were supplied, furnished to us, my lord. And my lord will see this in the affidavit in reply, my lord, I have filed those documents, my lord. If my lord will come to my affidavit in reply, my lord, from page 81 onwards, my lord, up to 86.
Yes.
My lord, from page 81 to page 85. These documents were of, my lord, the case, second case, that is Zinjia PS case number 49 of 24, my lord. Here, in these documents also, my lord, statement made by co-accused is incomplete and is not furnished. And my lord, the second part, page number 86, that is the first case, Biswanath Chariali PS case number 4 of 22. That is also not, my lord, complete, it's incomplete document. Page 86, my lord. Only front page they have given, my lord. No details, no other documents are there, my lord.
No, in both these cases, if you remember correctly,
Yes.
you are accused. You
Yes,
are
ma'am.
facing the trial.
Yes, my lord.
Those cases have not culminated as yet.
Yes,
The
my
trial is still continuing.
Yes, my lord.
And you say that these documents are not complete.
Yes, my lord.
It is not a case that you are not connected in those cases.
But
You are not.
this is, I understand, my lord, this is preventive.
No,
detention.
you have to see the actual prejudice caused. It cannot be a prejudice on paper. You are an accused in these cases, you are contesting this case. You are arrested, you are granted bail. Can you say, no, I do not know about those cases?
My lord,
Prejudice has to be real prejudice.
my lord, in this regard, my lord, as I have mentioned, that documents were incomplete, my lord, as it is preventive detention case, my lord. It was the duty of the detention authority to provide us the complete documents, my lord. And in this regard, my lord, I'm relying one judgment, my lord, will find Union of India versus Ranu Bhandari.
What is the citation?
Citation is the 2008-17 SCC 348.
348.
2008-17 SCC 348. Ranu, Union of India versus Ranu Bhandari. But relevant para is para 27.
Just a minute. Ranu Bhandari,
Ranu Bhandari, my lord.
relevant paras,
27, my lord.
27.
27. May I read, my lord?
Yes, please.
It has also been the consistent view that when a detention order is passed, all the material relied upon by the detaining authority in making such an order must be supplied to the detainee to enable him to make an effective representation against the detention order in compliance with Article 22(5) of the Constitution, irrespective of whether he had knowledge of the same or not. These have been recognized by this court as the minimum safeguards to ensure that preventive detention laws, which are an evil necessity, do not become instruments of oppression in the hands of the authorities concerned or to avoid criminal
We'll take a
proceedings.
break. We'll take a. What is your name?
Madam M. Rahman.
Mr. Rahman, we'll take a break of 5 minutes.
Madam.
minimum safeguards.
Come back.
Please, madam.
Yes.
So, my lord, I was relying on para 27 of the judgment, my lord, as it is constitutional mandate, my lord, that detention authority must fulfill these provisions, my lord. One another judgment, my lord, Zasila Savi, that recent judgment of the apex court, my lord, 2024 9 SCC 53.
Which one?
Zasila Saji, my lord, versus Union of India, it's 2024 9 SCC 53.
It's here?
Yes, here, my lord. All judgments, my lord, I'm citing, all
Yes.
are available.
Thank you. You've got it. Rasila Saji, assistant.
2024 9 SCC 53. Zasila Saji versus Union.
Para?
My lord, the relevant para is 23 onwards, my lord.
Twenty-three.
23 is about a discussion of a my lord, earlier case, my lord, that M. Ahmed Putti versus Union of India. But the relevant one is, my lord, 24. If we read 24, my lord,
24 is.
it can thus be seen that this court in M. Ahmed Putti, in unequivocal terms, has held that the constitutional requirements under Article 22(5) of the Constitution of India are twofold, namely, the detaining authority must, as soon as practicable after the detention, communicate to the detainee the grounds on which the order of the detention has been made. And number two, the detaining authority must afford the detainee the earliest opportunity of making the representation against the order of detention. It has further been held that the right is to make an effective representation, and when some documents are referred or to or relied or on in the grounds of detention without copies of such documents, the grounds of detention would not be complete. In unequivocal terms, it has been held that the detainee has the right to be furnished with the grounds of detention along with the documents so referred to or relied on. It has been held that failure or even delay in furnishing those documents would amount to denial of the right to make an effective representation. 25, my lord. This court further went to hold that it is immaterial whether the detainee already knew about their contents or not. This court reiterated the position that it being a constitutional imperative for the detaining authority to give the documents relied on and referred to in order of detention peri passu the grounds of detention. It has been held that there is no question of demanding the document. So, my lord, here in this case, documents were incomplete and complete documents were not furnished, my lord, as I have. My lord, annexed in the affidavit in opposition, my lord. It can be seen. So, my lord, my next round is that, my lord, documents which were furnished, not only incomplete, my lord, it was illegible too, my lord. Illegible in the sense, my lord will, if my lord will come to page number 81 onwards,
Yes.
all the documents, my lord, they have furnished totally illegible, my lord. So regarding this, my lord, illegible, my lord, I am may I, my lord?
Just a minute. These averments were, these pleadings, where have you stated regarding illegible documents?
My lord, in my writ petition as well as in my affidavit in reply, both. I have-
Which were?
Yes, just a minute, my lord. My lord, in the writ petition, my lord, will find this in para number. My lord, para 4 of writ petition.
with some.
Yes, my lord, served with some illegible photocopies of case record, my lord. Some means, my lord, out of two FIR, my lord, one FIR they have provided, except, my lord, statements made by prime accused. In the first FIR, in second FIR, my lord, it's totally missing, my lord, except the first page,
Where have
the-
you stated?
my lord,
Where have you stated this?
in para 4, my lord.
No, first FIR, second FIR.
My lord, it is in, then my lord will again have to come to the affidavit in reply I have filed. Well, I have annexed, if lordship comes to page number 81,
No, we are not on the annexure, we are on the pleadings, requirement of stating this.
pleadings, my lord, some illegible documents I have mentioned in the
That we have
petition,
seen, paragraph.
as well as, my lord,
Paragraph
in
4,
the
Some illegible documents you have said.
para 4, my lord, of the affidavit in reply, my lord,
Page
72.
72.
Yes, my lord, it's a long para, but for the last part,
62.
72, yes, 72.
I don't have.
72, last part, my lord. Apart from the order and grounds of arrest dated 5/6/25, some illegible photocopies and incomplete relied documents were supplied to the mother of the detainee. Thereafter, the detainee and his mother requested the DSP Biswanath to advise them what to do for the release of the detainee. The DSP Biswanath, instead of explaining the grounds of arrest and averments of the detention order dated 5/6/25 in a known language, that is Assamese, he misled the mother of the detainee to approach the respondent number 7 directly. So, my lord, what I have annexed here is the lordship, all the documents they have furnished. Out of two FIR, my lord, one FIR is partially complete and second FIR is totally missing, my lord. That is my humble submission. So, in this regard, my lord, I am relying two judgments, my lord. One is, my
You
lord.
have the records, Mr.
Yes.
Yes, in this connection, my lord, I am relying two judgments, my lord. Lordship will find 2022-9 SCC 509, State of Manipur and others versus Buyamaun Abdul Hannan. Asset. Two 2022-19 SCC 509, man. State of Manipur. May I read, my lord? Relevant para is, my lord, 22-23, my lord.
20.
22, my lord. State of Manipur and others versus Buyamaun Abdul Hannan. In this judgment, my lord, relevant para 22. Thus, the legal position has been settled by this court that the right to make representation is a fundamental right to the detainee under Article 22(5) of the Constitution, and supply of the illegible copy of documents which have been relied upon by the detaining authority indeed has deprived him in making an effective representation, and denial thereof will hold the order of detention illegal and not in accordance with the procedure contemplated under law. 23, it is the admitted case of the parties that respondent number 1 has failed to question before the detaining authority that illegible or blurred copies were supplied to him which were relied upon while passing the order of detention, but the right to make representation being a fundamental right under Article 22(5) of the Constitution. In order to make effective representation, the detainee is always entitled to be supplied with legible copies of the documents relied upon by the detaining authority, and such information made in the grounds of detention enables him to make an effective representation. My lord, likewise, one another judgment is also there, my lord, that was passed by.
Mr. Rahman, the issue here is this principle, there is no doubt on the principle of law that
My lord.
documents have to be given, furnished to you, documents have to be legible.
My lord.
You have alleged that the documents were incomplete and illegible.
Yes, my lord.
And to demonstrate that, you have enclosed those documents.
Yes, my lord.
See, in a writ proceedings, that cannot be held as an evidence. We have to, the aspect of appreciating evidence is very, very circumscribed in a writ proceeding.
My lord.
Therefore, we insist on a proper affidavit,
My lord.
verification of the pleadings.
My lord.
Now that verification, where the pleadings which you have given in both the cases, there is a discrepancy of the pleadings in the writ petition and the pleadings in the affidavit reply so far as the verification part is concerned. The verification is not by the petitioner, he is in detention.
Yes.
It is by his son-in-law or somebody. Brother-in-law. You have written son-in-law by mistake. Brother-in-law, one of the verification, he says it's personal knowledge. In the other, he says same statement, it is true as per records. But we are not on that. We are on the aspect that this fact which you have pleaded has to be admitted fact.
Yes.
If it is admitted that the documents which have been furnished to you are either incomplete or blurred or not legible,
Yes.
then there is no other option but to allow your repetition. But what we find that in both the affidavits, there are two affidavits. In paragraph 6 of both the affidavits, this aspect has been denied.
Yes.
So once there is a denial in a writ petition,
Yes, my lord.
so it becomes disputed questions of fact. We would still go by the records, like to see what is there in the records. But with this, will you be successful in convincing us
My lord, other
with a
grounds are-
disputed question of fact?
Yes, my lord, I'm
To
coming to
make
that.
out a case of interference in a matter of preventive detention, your facts cannot be disputed. You make out a case on law, but their facts cannot be disputed.
My lord, even if so, my lord, perhaps recording.
Records will.
Yes, my lord.
Will.
Yes, my lord, in the record, my lord, from the very beginning to this stage, my lord, they are failed to provide the vital document, that is statement of the prime accused. Without going through the statement of the prime accused, my lord, detention authority cannot come to a subjective satisfaction to pass this detention order, because my lord, in both the case, no contraband was seized from my possession. It was merely, my lord, that the confessional statement made by the prime accused, I was arrested, my lord. It was, I
See,
was
we
arrested.
cannot make any opinion on the trial of those cases.
No, no,
Neither we are examining that matter, neither we are at appellate court. Those matters are within the domain of the trial court.
no, I'm not on that, my lord.
So,
I am on the statement, my lord, made by the prime accused.
no, we do not know that if those trials had culminated either in an acquittal manner or in a conviction, those are still in the trial stage.
No, my lord, I mean to say, my lord,
Let us see the grounds
Yes,
here.
ma'am, please.
You show us the
are
ground.
vital documents which were relied
Show us the ground.
to
first.
pass this detention order, my lord.
No, let us see the grounds of your detention here.
Yes,
Let us see, we have to examine those vis-a-vis the matrix.
my lord, grounds is at page number 18,
1-8.
1(8) of the writ petition.
Yes, please. Yes,
So these are the grounds of detention they furnished, my lord.
yes.
First is point number 1 is introduction, my lord, and point number 2 is, may I read, my lord?
Yes, please.
Point number 2, it is confidently learned that you started illegal trafficking of narcotics and psychotropic drugs as drug peddler for last several years. Further, you are associated with various other cases. My lord, this one is the another line, my lord. Further, you are associated with various other cases. That means, my lord, out of these two cases, there are other cases. They have said, my lord, admitted this, but there is no whisper, no, they were totally silent in affidavit as well as, my lord, in the grounds of detention and order, my lord.
Before this line,
Yes.
is there any mention of any case?
Yes,
You have said that there are other cases other than these two, but
Yes.
is there any mention of these two cases before this line?
no, my lord.
Then
Further,
you can assume
yes,
these other cases are referring to these two cases.
my lord. Associated with very other cases, you are involved in Biswanath Sariali PS case number.
These are the two cases. Other
Yes.
cases are these two.
Yes, yes, my lord. The district police has already registered 2 numbers of cases under NDPS Act, and during investigation, it is found that you are involved in the business of drugs. Number 3, it appears from the record that on 6/1/2022 at 8 AM, information received regarding illegal selling of drugs by you at Ambari Biswanath. The police conducted search operation in presence of witnesses. During search, police recovered 6 grams of heroin, including vials from the possession of one Sri Pankaj Gupta. So, my lord, it was not from my possession. Son of so and so, so and so, so and so. During interrogation, the said accused person stated that the above heroin was purchased from you and your accomplice. Accomplice, sorry. So accomplice. So, my lord, my question is that, my lord, this last line, during interrogation, the said accused person has stated. So, my lord, there must be the statement made by the accused, my lord. And statement is missing in the entire record, my lord. Neither they have furnished nor. Yes, yes, my lord. So further, 31(5), so and so, the information received that 2 individuals, you and your accomplice, compelled a minor boy, Subham Sundi of class 10, a class 10 student of Monabari High School, to engage in drug trafficking at Monabari under Zinjia PS. The police conducted search operation in the house of Subham Sundi at Monabari, and during the search, and said minor boy willingly produced the NDPS items, which were 29 plastic vials containing heroin 36 grams. The minor boy was compelled to conceal the NDPS item in his house by you and your accomplice. So here again, my lord, no contraband was seized from my practical position, my lord. The next page, my lord, during the investigation, you were arrested, and after proper interrogation, it was found that you and other individuals were operating illegal drug business in the Biswanath Sariali area. This refers to Biswanath Sariali PS case number 4 of 25 and Zinjia PS case number 49/24 under the NDPS Act. In the course of investigation, sufficient evidence against you and your accomplices was found, and on completion of the investigation, charge sheet were submitted against you and your accomplices in both the FIR, my lord.
Yes.
The bold portion, my lord. The photocopy of FIR, FSL report, Caesar memo, GD extra, counterfoil of CS of both cases are annexed herewith. So, my lord, the prima facie it appears, my lord, the statement of co-accused is not there, my lord.
What is the GD extract?
GD extract, that is also illegible, my lord. What they have written, we don't know, my lord, in the GD extract. Because in both the case, as I have mentioned, my lord, both the case is at appearance stage, neither such has been framed nor, my lord, anything, my lord, proceeded since 2022. It's 2025, both the cases at appearance stage, no charge has been framed against me, my lord. So in the bold part, my lord, the statement of accused is missing. And one more thing, my lord, that both they have mentioned both the cases, but here lordship will find only one cases they have provided, that is also partially, and in other cases, my lord, it is totally missing. So I'm coming to the number 4, my lord. From the above cases, it is evident that you have involved yourself in the crime of illegal trafficking of drugs in Biswanath district. You are engaged in illicit drug trade, turning a large number of youths into addicts, harming not only their health and future, but also depriving the nation of quality human resources. This has a detrimental effect on society at large and encourages addicts to engage in criminal activities. Further, you are found to be a habitual offender of such illegal drug trafficking in violation of NDPS Act. Despite your arrest in different cases, you have neither mended your ways nor shown any remorse for your criminal acts, and you continue to engage in criminal activities with the help of your accomplices. My lord, the last line, here I have mentioned in my petition, my lord, as well as in the counter affidavit, my lord, that affidavit in reply, sorry, my lord, affidavit in reply, that, my lord, currently means for last 1.5 years, my lord, I am running a pig farm in my house, and DSP Biswanath verified it in presence of witnesses, my lord. So number 5, my lord, at present you are out on bail. At present, you are out on bail. Your release appears to be seriously detrimental to society, as there is a high likelihood of you resuming illegal drug activities in the Biswanath district. My lord, in this regard, I'm relying. I will come, my lord, that I'm relying some judgments relevant to this para number 5, my lord. So what they have said, my lord, at present you are out on bail. So, my lord, I am out on bail, my lord, where NDPS 37 is very much there in the NDPS Act. They would have come by 37, my lord, but in the during the bail, my lord, neither any objection was there, my lord, nor in the letter states they have mentioned anything regarding bail, my lord, in the retention order.
Where is the bail order?
Bail order is, I have annexed, my lord. Lordship will come to affidavit in reply, page number 88.
Pages are little different.
Pages 88, my lord.
What is the bail number? Bail application?
Bail number is, my lord, one case, bail number is 275 of 22.
I am having a different page number, but anyway, I will.
No, my lord, in affidavit in reply.
My page number is 91.
91. It's 91.
92?
Oh.
It's okay. This time it's.
Okay, my lord, bail number 275 of 22. The first case, my lord.
Yes. It's on length of detention, right?
Yes, my lord. It was disposed of 11 March 2022. Small quantity case, my lord, it was. And in a small quantity, my lord, 6 months is the maximum imprisonment.
Now it is bailable in a.
Bailable, right? Right, my
Jurisdiction of Guwahati High Court.
right, my lord. It's bailable now. So the next one is the next one is bail application number 2183 of 2024. That was disposed of on 37 2024.
More than 60 days.
But in this regard, I'm referring one judgment of the apex court, my lord, Rajinder Arora, my lord, versus Union of India, 2006 4 SCC 796. 2006 4 SCC 796. Rajinder Arora versus Union of India.
Have you given this?
As far as Rajinder Arora versus Union of India, relevant para is 21 and 22, my lord.
Anyway, you see, Rajinder. One second. Nice to meet you.
It's not there.
My lord,
Might have missed, but I just.
No, they are not. Rutan upon Rajendra Arora.
no,
You have not given Rajendra
my lord,
Arora.
I'm placing it. My lord, Rajinder Arora is there, my lord. My lord will come to page, para number 21 first, my lord. Para number 21. The earlier case was discussed, my lord. The question as regards delay in issuing the order of detention has been held to be a valid ground for quashing an order of detention by this court in T.A. Abdul Rahman versus State of Kerala, stating, para 10, my lord, the conspectus of the above decisions can be summarized thus: the question whether the prejudicial activities of a person necessitating to pass an order of detention is proximate to the time when the order is made, or the live link between the prejudicial activities and the purpose of detention is snapped, depends on the facts and circumstances of each case. No hard and fast rule can be precisely formulated that would be applicable under all circumstances, and no exhaustive guidelines can be laid down in that behalf. It follows that the test of proximity is not a rigid or mechanical test by merely counting number of months between the offending acts and the order of detention. However, when there is undue and long delay between the prejudicial activities and the passing of detention order, the court has to scrutinize whether the detaining authority has satisfactorily examined such a delay and afforded a tenable and reasonable explanation as to why such a delay has occasioned when called upon to answer, and further the court has to investigate whether the causal connection has been broken in the circumstances of the case. Similarly, when there is unsatisfactory and unexplained delay between the date of order of detention and the date of securing the arrest of the detainee, such a delay would throw considerable doubt on the genuineness of the subjective satisfaction of the detaining authority, leading to a legitimate inference that the detaining authority was not really and genuinely satisfied as regards the necessity for detaining the detainee with a view to preventing him from acting in a prejudicial manner. The delay cost, next para, the delay cost in this case in issuing the order of detention has not been explained. In fact, no reason in that behalf whatsoever has been assigned at all. So, my lord, my last Ellis case was, my lord, in 2024. Since then, my lord, till the passing of detention order is gap of 11 months. So there is missing live proximate links, my lord, between Ellis offense and the need of the detention of the detainee, my lord. So in this regard, my lord.
24 was the last time that case was
Yes,
registered.
my lord. Last Ellis offense.
Which part of 24?
My lord, the date is there, my lord.
That would be relevant perhaps.
Yes,
Since
that's
we are
the
looking at
lord,
the
date is
time
there.
gap.
Date 31 August, they filed charge sheet prior to that trip.
Mid 24. Say mid 24.
My lord, May 24, yes.
Mid-
May 24.
Middle of 24.
Yes. So, my lord, since then, it is 11 months passing, my lord, till the passing of the detention order. Another judgment, my lord,
No, the grounds which have been cited
my lord.
is alleged misuse of the bail. Is there a date when such misuse was there?
No, my lord.
It is not a
Nothing.
question, you cannot link, if you are urging this ground, you have to link it with the facts of the case.
Yes, my lord.
The
my lord.
filing of the charge sheet in the earlier cases is not the determining factor. The date is when you have found to be misusing the bail and indulging in activities against the NDPS Act.
My lord, what happened?
So that is the reason of your preventive detention.
Yes, my
isn't
lord.
it?
When
So what is that proximity?
the proximity is that, my lord, when they have at least that last offense is 2024 and the previous offense was of 2022.
For those cases, you have not been put into PIT and DPS. Those offenses are not the proximate reason. Those are no doubt connected. But it appears the reasons is that when you were granted bail in the NDPS offenses, you were found to be indulging in similar activities, which necessitated your detention under PIT and DPS. Now, when did this necessity arise? It is not the filing of the charge sheet in the earlier cases. There you are facing trial. Have you got our point?
Yes, my lord. My submission is that, my lord, there should be continuity.
Exactly. So to put in the facts,
And-
the ratio laid down in Rajinder Arora,
Yes.
applicable in your case,
Yes.
you have to make out a case that there is a delay on two aspects.
Yes.
One is the prejudicial activities and the passing of the order. Number one. Prejudicial activity you cannot link to the earlier cases. Those you are already facing trial. prejudicial activities for this order
This case.
is your activities which you had done when you are on bail. When are these activities?
In connection with this.
Pit order.
Then my lord will come to another judgment that Malada.
No, there is
case-
another factor. There is date of the order and securing the arrest. That is not your case. When are you put behind the detained in this case?
In this case, my lord, 11-6.
11-6, and the order was 5-6.
5-6 order, but my lord, that continued since 24 May 2024 to till 5-6, my lord. The gap between this period, my lord. But this is rightly discussed, my lord, in the judgment, my lord. I'm coming in the Malada case.
No, no, those have to be applied to the facts.
Yes.
Filing of the charge sheet in the case before the trial court may not have any direct relationship with your present arrest.
My lord, in every cases, in PIT NDPS, my lord, cases registered under PIT NDPS based on the previous offences, my lord, because they are, my lord, only allegation is that I may involve in future crime, my lord, not in the past, my lord. So that apprehension is there, my lord. For that apprehension, PIT NDPS is that I am under PIT NDPS. My lord, will come to Malada case freedom, my lord. That one judgment, my lord, 2013 SCC 537.
So this order was 11-6-25. Which one?
He was alleged to be violating the bail conditions of which of these cases? The Jingle?
My lord,
He was alleged to be in exercising preventive detention powers. The petitioner was alleged to be violating the bail condition.
yes, my lord,
Which of the police cases? This one actually one or the India or the?
my lord, in both the cases, I did not violate any conditions, my lord, put upon me, my lord, during the that period, my lord, bail period. And when my lord, case is at appearance stage, I'm facing the trial. So my lord, my humble submission is that, my lord, first, my lord will come to that Malada case freedom, para number 11, my lord. My lord, from the bottom, line number 7.
What is the name of the case?
My lord, Malada case freedom 2023 13 SCC 537.
Malaga.
Yes, my lord. Para 11, my lord, middle part, from the bottom, my lord, line number 7. May I read, my lord?
Yes. Sorry, can you repeat the paragraph?
Para 11, my lord. Para 11, from the bottom, my lord, it's line number 7, my lord. May I read, my lord? My lord, that relevant part, my lord, in the counter affidavit, which was filed before the High Court, the detaining authority expressed only an apprehension that the acts on the basis of which the affairs were registered were likely to be repeated in the future, thereby giving rise to an apprehension of a breach of public order. The High Court has failed to probe the existence of a live and proximate link between the past cases and the need to detain the detainee after 7 months of registration of the first affair and nearby 5 months of securing bail. So exactly in my case, my lord, it is 11 months of gap, my lord. 11 months of gap. My lord, these things were clearly discussed in a judgment which was passed by this honorable court, my lord. That is, my lord, WBC criminal number 14 of 25.
Name,
WBC criminal number,
name.
sorry, WBC name is that, my lord, Selim Faraji. MD Selim Faraji versus Union of India. WP criminal number 14 of 25. Relevant para is 31. WP criminal number 1425 Selim Faraji.
Paragraph.
Paragraph number, my lord, 31 and 32. I'm coming to 31, my lord. So, my lord, in 31, in this case, my lord, all total 5 cases were there, my lord. These were discussed. And in the latter part, I'm reading out the relevant para, my lord, the last bottom 3, number 3 line, my lord.
Para.
Para 31. My lord, in that case, all total 5 cases were there against the detainee, and these were discussed. And accordingly, my lord, 31 para, my lord, the page number 20 of the judgment, my lord, page number 20, para 31, from the bottom 3rd line, my lord. May I read, my lord? Page number 20.
Yes, para
The-
31. It emerged.
Para 31, my lord. From the bottom 3rd line, my lord. Thus, there was a gap of about 9 months in forwarding of the preventive detention proposal from the last prejudicial activity alleged against the proposed detainee, and there was delay of more than 4 months on the part of the detaining authority to pass the detention order after receipt of the proposal for preventive detention. So, my lord, in this case, it was 4 months only, but in my case, it's 11 months, my lord. Then in 32, my lord,
Yes, please. Yeah, Abdul Rahman, you have just read.
yes, that is why, my lord. My lord, if lordship come to the page number 22 of the same judgment, my lord, that is under para number 33, but in the page number 22. Page number 22. My lord, in the middle part, in Sushanta Kumar Banik, the
Yes.
proposal to pass an appropriate order of detention under the provisions of the PIT NDPS Act was submitted by the concerned superintendent of police on 28/6/2021, and the detention order was passed on 12/11/21. The Honorable Court has found that the circumstances indicated that the detaining authority, after receipt of the proposal from the sponsoring authority, was indifferent in passing the order of detention with greater promptitude, and as there was no explanation as regards the delay, the live and proximate link between the grounds of detention and the proposal of detention had been found to have been snapped. My lord, Sushanta Banik is also there, my lord. I will come in the later part because the other grounds will cover that judgment, my lord. So, my lord, my humble submission is that, my lord, regarding that live link, my lord, no, not a single whisper is there, no explanation is there, my lord, in my case as well, my lord.
Yes.
So, my lord, regarding section NDPS, my lord, that are
No, the link is there, but the thing is that the link is prima facie there, but whether that is proximate, that is your point.
proximate and as well
That
as,
we
my
have to
lord,
see.
explanation part, my lord. That gap of 11 months, no explanation from the respondent, from respondent number 2, my lord. Either in the affidavit or in the detention order or in the grounds of detention, nowhere, my lord, no discussion, no whisper on delay part, my lord, or delay part as well as the proximity link, my lord, how it is connected, my lord. My lord, regarding section 37 and bail stage, as your lordship was asking, my lord, that during the bail stage, my lords, they would have come with the stringent part of the NDPS Act, my lord, section 37, during the bail stage, and they missed that opportunity, my lord. Now, my lord, this part, my lord,
These are the commercial quantity, the other two cases.
no,
Commercial.
that
What
one
is
is small quantity,
small
my lord,
quantity. The
and
other
other one is intermediate
Intermediate.
quantity. And that is too, my lord, not recovered from my possession. It was from other person. Based on the
That's
confessional
another
statement, I was arrested. If lordship will come to another WP criminal 14 of 22 passed by this honorable court. WP criminal 14 of 22, Debarshi Kashyap. My lord, though there is no bars, that my lord, PIT and DPS can be registered against any my lord, offense, irrespective of small, intermediate quantity or commercial quantity. But in general, my lord, against commercial quantity, PIT and DPS used to apply, my lord. But here in this case, my lord, why I am saying, my lord, that without application of mine, my lord, that respondent number 2, my lord, passed this detention order, because, my lord, it's small quantity in one case. That is true, my lord, not recovered from my possession, and no that confessional part is there, my lord. So, my lord, in the WP criminal 14 of 20, my lord.
This is a single bench.
My lord, yes, my lord. Oh,
What is the name of the case? 13 of
my lord,
how keep.
Debarshi Kashyap, my lord.
Debarshi.
WP criminal, Debarshi Kashyap. It was
Refer
passed
a
by
single bench.
single bench, my lord.
Not refer a single bench.
Then, my lord, will come to that Amina Begum versus the state of Telangana, my lord. 2023 Live Law SC 743.
Amina Begum.
Yes, my lord.
Question?
Yeah, I mean,
My lord, para 51, middle part, my lord, just after the section 41A of CRPC, my lord. My lord will find 1, 2, 3, 4, 5, 6, 7, 8. 8 number para, my lord. 8 number line, my lord. Para number 51, 8 number line. It is pertinent, may I read, my lord?
Yes, please.
It is pertinent to note that in the 3 criminal proceedings where the detainee had been released on bail, no application for cancellation of bail had been moved by the state. In the light of the same, the provisions of the Act which is an extraordinary statute, should not have been resorted to when ordinary criminal law provided sufficient means to address the apprehensions leading to the impugned detention order. There may have existed sufficient grounds to appeal against the bail orders, but the circumstances did not warrant the circumvention of ordinary criminal procedure to resort to an ordinary measure of the law of preventive detention. Here in this case, my lord, during the bail stage, they did not came for cancellation of bail, neither they made any objection under section 37 of NDPS Act, my lord. So those parts were missing, my lord. Still they passed this detention order under PIT NDPS, my lord. You know, one division bench order is also the order is also there. my lord. Name is that Pramod Yadav. Alias Tinku.
Have you given copy?
Yes, my lord. Pramod Yadav is there, my lord. Pramod Yadav alias Tinku, WP criminal 33 of 24.
Yes, Pramod Yadav is there.
Yes, Pramod Yadav alias Tinku, my lord. Para number 27. May I read, my lord?
Just a minute, please.
Para 27.
Para 27. Page number 14. Under such circumstances, the lack of consideration of the rigors of section 37 of the NDPS Act 1985 in the grounds for detention served to the petitioner on 28/5/2024 has to be held to have vitiated the detention orders. Therefore, on point of determination number B, the court is inclined to hold that non-consideration of the provision of section 37 of the NDPS Act in the grounds of detention has vitiated the detention order. So, my lord, in the grounds of detention, no whisper on section 37 as well in my case also, my lord.
What was the facts of this case?
Facts of this case was, my lord, during bail stage, my lord, section 37 was not, they failed to make any objection under section 37 of NDPS, and my lord, there was no cancellation of bail as well, my lord. Similar things, my lord, in my case, my lord.
So they
Detention
invoke
authority-
preventive detention
Yes, my lord.
thereafter.
Yes, yes.
No, any order passed wherever 37 is applicable, any bail order passed, there are many decisions.
Yes,
Because
my lord.
our court also that any decision passed without considering 37 would be
Yes,
incorrect
but-
and void almost.
My lord, in that fact, my lord, detention authority had a chance to come before the court for cancellation of bail as well, my lord, which was not done.
It can be cancelled on that
Yes,
ground.
which was not done.
And
So, my
somehow
lord, if it is
interfere.
not done, at that stage, why
I-
PIT and DPS, my lord, in latter stage after 11 months?
No, the same court will not be able to cancel. The
Malak.
30 even if it is, it has not considered 37.
Yeah.
I think. Higher court, anyway, it's active. So thereafter they invoke this in this particular case, right?
My lord, even in Susanta Banik also, my lord, this section 37, failure to fulfill this ground, my lord, the order was vitiated under Susanta Kumar Banik versus State of
Okay, we'll come back at 2 o'clock.
Tripura.
Mr. Das, which matter? which you don't want to do today.
Right, my lord, there was some urgency. It
You
was
want
before
to
we-
do or you don't want to do?
I'm sorry, my lord.
Do you want to do or you don't want?
I
to?
want to do it.
Want to do?
Yes,
Then we'll
very
have
much,
it.
because it went before division bench. Division one of the judge cannot take up the matter, so it was special. bench
Item
was
number?
constituted. Item number 9, my lord.
What is the matter?
Item 9.
What
It's
is
a PIL which has been filed by my learned friend. Now we had a manufacturing unit. Now they said by notification, we cannot run that unit. And there was a status quo order which is by division bench. Now we are
PIL against what? PIL for?
There was an order, the consent to establish order, which was expired in 2012.
Of what? What industry?
It's a,
It's a coke. Not coke means
it's a CPC, calcium petroleum coke. Out of
Who are
which
the
a lot-
parties?
It's a PL file that Mr. Kane Shoddy is leading this.
No,
case.
who are the parties?
Parties is NOC Foundation. It's a foundation.
No, who are you?
Here, he is the beneficiary of
Name,
MM
name,
Carbon.
name.
MM Carbon.
MM Carbon. Okay, we'll see. There's, let us see the records. Records. PIL record. CPC, RPC are very familiar terms for this court. So let us have a look. This court might have a
Yes.
difficulty.
GPC, RPC are common. MM Carbon.
how many MM carbon?
MM Carbon.
Did not have a difficulty, yes.
I think no, Lordship will not have any.
No difficulty.
No difficulty, I think. Because
Who are
there,
you?
there
Who are
is-
you?
I'm an NOC Foundation.
NOC Foundation means?
It's a foundation who, they have filed this PL because the a consent to establish was given in 2011, which
Okay.
was not
So that's the point, my lord, where you have raised preliminary object regarding maintainability of the case.
that is,
They are from Delhi. They have no connection with the state.
that will be.
They are from Delhi, no connection. I will show it, my lord. We have taken that objection also.
People in Delhi are not connected with us,
No,
huh?
they have connection. I am not saying, but in this case, it doesn't have.
Okay, let's see. We'll, I think this matter will take some time, Mr. Goswami will take some time.
Yes,
And Mr. Kane Shoddy is also, is fixed matter at 2 o'clock.
2 o'clock, otherwise, in any case, we cannot have it at 2
That's,
o'clock. Maybe after 2:30, maybe we do not know.
No.
Mr. Raman
Yes.
finished, then Mr. Goswami is there.
we find,
2:30 kuntu matter. 2:30 quarter nine, no? Even one request is for item number 20, item number 8 is also 18. 18 is also, request is there for 2:30. Let us see.
my request also is being now being made. Because there is some.
The request which came on earlier point of time has to be given.
Yes.
10:30 request.
That's right.
But
That's
we'll
right.
try to accommodate.
Yes, yes.
May I please, Your Lordship?
Yes, please.
Lordship, the last Brahman, I was relying,
Pramod Jadhav.
yes, my lord. Basically, section 37, I was making submission on section 37, my lord. My lord, whether section 37 will apply in my case or not, my lord, that will clarify by the judgment, my lord, Susanta Kumar Banik. Susanta Kumar Banik, 2022 Live Law FC 813, my lord. Live Law reported judgment. 2022 Live Law SC 813. Yes, sir. May I proceed, sir?
Just a minute, Sushanta.
Yes, Sir Sushanta Kumar Banik versus State of Tripura. 2022 Live Law SC 813.
Yes.
My lord, before going to the relevant para, my lord will first come to the page number second, which is just second page, my lord. Second page, in the bottom, my lord, point number 2. In that point, my lord, Sri Sushanta Kumar Bonik, son of so and so, again got involved in East Agartala PS case number so and so, under section 21B of 29. That is, I mean to, my lord, this is intermediate quantity. So in my case also, my lord, one case is intermediate quantity and other one is small quantity. So now my lord will come to para number 22 of the said judgment, my lord. As noted above in the case on hand, in both the cases relied upon by the detaining authority for the purpose of preventively detaining the appellant, herein the appellant was already ordered to be released on bail by the concerned special court. Indisputably, we do not find any reference of this fact in the proposal forwarded by the Superintendent of Police, West Tripura District, while requesting to process the order of detention. The reason for laying much stress on this aspect of the matter is the fact that the appellant, though arrested in connection with the offence under the NDPS Act, the Special Court Tripura thought fit to release the appellant on bail despite the rigors of Section 37 of the NDPS Act. Section 37 of the NDPS Act reads thus. Now, my lord, will come to para 23. A plain reading of the aforesaid provision would indicate that the accused arrested under the NDPS Act 1985 can be ordered to be released on bail only if the court is satisfied that there are reasonable grounds for believing that the accused is not guilty of such offence and that he is not likely to commit any offence while on bail. If the appellant herein was ordered to be released on bail despite the rigors of Section 37 of the NDPS Act 1985, then the same is suggestive that the court concerned might not have found any prima facie case against him. Had this fact been brought to the notice of the detaining authority, then it would have influenced the mind of the detaining authority one way or the other on the question whether or not to make an order of detention. The state never thought to even challenge the bail order passed by the special court releasing the appellant on bail. So, there was no initiative from the respondent number 2 or 7 for cancellation of bail. Again, one order.
But here there is one catch. The third line of para 22. Indisputably, we do not find any reference of this fact in the proposal forwarded by the Superintendent of Police.
Yes, my lord. Here in this case also no reference was made on this aspect, my lord, by the respondent number 7.
Regarding grant of bail.
Yes, my lord, regarding bail part and regarding cancellation of bail.
The
of-
cancellation comes separately,
Yes, my
but
lord.
that has been referred.
In the counter affidavit also, my lord.
No.
No whisper.
In the
That he is on bail and that there is no petition for cancellation.
Yes, my lord. And these things are not disclosed by the respondent number 7.
It's not there in the
Yes, sir.
the detention order.
As well as in the affidavit, my lord. They have filed affidavit. In the affidavit also, this part is missing, my lord. Totally silent on this aspect, my lord. No whisper.
But there is clear mention. Why would there be a requirement of preventive detention? There is clear mention of 2 police cases in this detention order
Yes,
grounds.
yes.
If you are behind the bars, why will there be a necessity of preventive detention?
That will, my lord.
Whether you are on bail or not even been arrested, You can be arrested in those cases which you were granted bail.
Yes,
Thereafter, the authority thought it fit to put you under pit.
yes.
That automatically, will that be a reason that they have to mention that you are on bail?
My lord, in my lord, PIT and DPS cases, especially in preventive detention cases, my lord, these are the grounds, my lord.
No, Mr. Let us not be oblivious to the real facts. Why is the requirement of preventive detention? Because you are outside.
Yes, my lord, I am outside.
So if you are inside the jail, was
Yes.
there any requirement of PIT? There is no
Yes.
requirement. So only because your bail thing has not been mentioned in the order, will it vitiate?
My lord, if, my lord, this detention order was passed.
If
but
nothing was
because-
referred, no case referred, only on vague allegation that you are seen, you may be apprehending that you may be indulging in this kind of activities, we put you in PIT. That is not the case.
My lord, in preventive detention case, especially in PIT and DPS, my lord, case registered because my lord, earlier it was their apprehension that earlier I was informed. In future, my lord, I may involve in such.
So the
Offense, madam.
aspect of you being granted bail in the earlier case not being mentioned in the order, will it make any difference?
My lord, definitely as per my lord citations, they discuss my lord.
No, let us not be totally, we cannot forget what is going on. What is the main facts? Let us not lose our common sense.
Yes, my lord, in
Unless you are outside on bail, where is the requirement of a PIT?
that is my lord, respondent number 2 will tell my lord, because I was on bail. I was in both the case, my lord, which were relied, my lord. In both the case, no contraband was seized from my possession. It is
No, that
still under.
those are different factors.
My lord, this proposition was further discussed.
Yes.
This proposition was further elaborately discussed in my lord, in our one judgment, my lord, passed by this honorable court in WPC 4639 of 21. 4639 of 21. Zan Parikh first, alias Sanjoy Parikh.
This, yeah?
Yes, my lord. WPC 4639, Zan Parikh at Sanjoy Parikh. Friends, I have given 2 copies of it. There was no initiative from the respondent side to cancel the bail, my lord. And in that judgment, my lord, para number 10 and 11 has discussed this aspect, my lord. May I read, my lord?
Anyway,
Perhaps it's this side, my lord.
Jan Parikh, right?
Yes, my lord.
Sanjay Parikh.
Para number 10, my lord, admittedly, in the present case, the procedure as laid down by the law has not been followed. No urgency was shown while deciding the representation of the petitioner by the government, which was submitted by the petitioner on 9/7/21. Although the rejection order dated so-and-so does not reflect that it is being rejected on the advice of the advisory board, which was received on so-and-so, but the fact which is material for consideration would be that the order itself was passed after the decision of the advisory board was received, my lord, the relevant portion is para number 11, my lord. 11. 11 second part, my lord, that under the normal circumstances, the cancellation of bail could have been the proper remedy for the state, as the concerned court would have been well within jurisdiction to have considered cancelling the bail of the petitioner had there been appropriate material before the court to show that the petitioner is a repeated offender under the NDPS Act. We must say very clearly that the observation we are making of, my lord.
Now, what is this reference? Why is for this reference for?
My lord, actually, para number 10 was, I was relying because of that advisory board's order. Later on, I will come, my lord. It's wrongly, I actually cited this para number 10. Otherwise, para number 11 is relevant, my lord. The cancellation of bail was not there, my lord.
Yes.
Yes, sir. Yes, my lord. My lord, one more ground, my lord. I am relying that when the order was executed upon me, my lord, by the DSP Biswanath, on that day, my lord, what happened, I have categorically mentioned in my petition as well as in the affidavit in reply also, my lord, that the DSP Biswanath, though furnished the order, detention order and grounds of arrest to me, my lord, but my lord, he was failed to make her understand, my lord, to know the details of the grounds of arrest, my lord, in my known language. Because, my lord, being an illiterate lady, my lord, I know only Assamese, my lord. I do not know English. So, my lord, I requested him, my lord, to make us, my lord, to understand the grounds of arrest, my lord, in Assamese. But instead of,
You're a lady.
my lord,
Mother.
mother, I'm talking about the mother of the detainee. Detainee was already taken into custody at that
Yes,
moment.
Yes.
Yes, order was handed over upon me, my lord.
Mm.
So I requested the DSP Biswanath, my lord, but he instead
Now,
of
when were you taken into custody? On
11,
11/6.
11/6, my lord.
When was the order furnished to you?
11 only.
11. It
11.
was given to you.
Given to my mother, my lord. Given to my mother. Actually, DSP Biswanath called both my mother and me, my lord, each quarter. I have mentioned in the.
You are also illiterate.
I'm my lord till metric, my lord.
You're not illiterate.
But my lord, a metric student, my lord, how I understand English, my lord, English grounds of grounds of detention, my lord. I requested him.
No,
my
you are
lord,
talking about your mother. Mother is not connected.
mother is there. Those orders and grounds of arrest were supplied to my mother,
Not to you.
not to me, my lord. It was handed over to my mother. I was present there, my lord. My lord will. I want to clarify that my lord will come to if
At the time of detention.
yes, my lord. My lord will come to para 4 of the affidavit on reply, my lord. There, everything I have stated, my lord. How I was called, how I was taken into detention, everything is there in para 4, my lord. So I requested,
What is your case? That you did not understand the ground.
for that reason, my lord, I could not submit effective representation before the concerned authority. I had to settle from here and there, my lord, because of that misled by the DSP Biswanath, my lord. Just for a moment, if lordship come to para number 4, page number 72, my lord.
Now, let us see in your writ petition. You cannot improve your ground
Yes, my lord.
in the reply.
Yes,
Let us see in the writ petition.
yes, yes, in the para, my lord, in the read petition also, my lord, I had. My lord will come to para 2 of the writ petition, my lord.
2.
2.
Yes, please.
May I read, my lord? That the petitioner begs to state that all
Only the
11
relevant part.
Okay, hello. Whether the house go according to the petition. Yes, my lord, from the 1, 2, 3, 4, 5, 6, 7, 8. My lord, 6 line, 1, 2, 3, 4,
Probably.
5, 6,
Yes,
7.
accordingly.
8 line, accordingly, madam.
Yes.
Accordingly, the petitioner
Sign
was
some
a
papers.
the-
Yes,
a-
thereafter. where
quarter
it-
of Deputy Superintendent of Police DSP Biswanath, where the petitioner was compelled to sign some papers. Thereafter, the police personnel served a copy of detention order dated 5/6/25 along with a copy of grounds of detention as well as some illegible photocopies of case records to the mother of the petitioner. Thereafter, the petitioner was taken to the police station and forwarded to the Biswanath District Jail. Since then, the petitioner is in detention under the Biswanath District Jail. So, my lord, now my lord will come to my affidavit in reply, page number 72.
Yes,
Page number 72, para number 4, that is, my lord, 6 number line, my lord. The officer of the respondent number 7, DSP Biswanath, instructed the detainee and his mother to come to his living quarter by next day, that is 11/6/25, and accordingly, the detainee and his mother arrived at the living quarter of DSP Biswanath, where they were informed that the detainee is detained as per order dated 5/6/25 issued by respondent number 2, and thereafter the officer took some signatures in some papers and handed over the order along with the grounds of arrest dated 5/6/25. Apart from the order and grounds of arrest dated 5/6/25, some illegible copies and incomplete relied documents were supplied to the mother of the detainee. Thereafter, the detainee and his mother requested the DSP Biswanath to advise them what to do for the release of the detainee.
how have you verified this?
My lord,
How have you verified this averments? How have you verified these averments in your reply?
My
Well,
lord-
this is an improvement. You have not stated in your
my lord,
petition.
in that
Nonetheless, it can be termed as pleadings. How have you verified?
my lord, in that case, lordship made
How
asked
have
the
you verified?
Affidavit.
In the affidavit,
This para is from knowledge or?
this para is from records. Your mother-in-law is illiterate, doesn't know English. That is a matter of record.
my lord, she was present there and
No, this
she
affidavit is by
described
Binod, who is your mother is his mother-in-law, and he says from records that my mother-in-law is illiterate. She doesn't understand English.
my lord.
You are apparently you are trying to improve your case. Okay, let us give you the benefit of doubt. But
My-
how have you verified? You have failed in the verification process.
My lord, they misled us. One proof is there, my lord, that one evidence is there that after his advice, my lord, we went to the SSP Biswanath by the
These are all statements which you have verified as matters of records. Misleading, these are all personal things. Mother being not aware of English, she is illiterate. And this should have been the first point in your petition, grounds we have not understood. After filing of the rejoinder of the affidavit in opposition, you filed in the reply that you do not understand.
my lord, why I had to settle here and there, my lord. Page number 30 of my writ petition will disclose, my lord. Page number 30,
Those we have seen. Those we have seen. Page number
page number 29 and 30, my lord.
29.
Just because DSP misled us, my lord, we could not submit effective representation before the concerned authority. And this was the proof, my lord, because we went to the SSP Biswanath. 17,
But
yes,
has the advisory thing, has it been considered or is not considered? It's considered.
not considered means, my lord, they have not even gave us any receipt copy also, my lord. I have mentioned in the writ petition, my lord. And thereafter, my lord, I had to settle here and there, and thereafter, my lord, on 27, 2025, I submitted representation before the superintendent of jailer, my lord, to communicate that representation to the respondent number 7, respondent number 2, my lord, that is Women Political Secretary. My lord, thereafter what happened,
Yes.
that my lord, that respondent number 2 referred the case to the before the advisory board. Perhaps on 14/7, my lord. Records will disclose, my lord. 14/7,
Yes. Thirty-one and 30, these are all your representations.
yes, my lord. So what happened, my lord, when it was referred before the advisory board, that is 14/7/2025. And then, my lord, I filed one another representation after 17/5, which was filed 17/6, which was filed before the SSP Biswanath. Thereafter, I filed one another representation, that is, my lord, 20/07/2025 by the mother of the detainee, my lord, before the jailer Biswanath, my lord, superintendent of jailer Biswanath, on 20. But on the same day, we came to know that my lord detainee was taken to Guwahati to produce him before advisory board. So jail authority advised us to come after 3-4 days, my lord. So accordingly, we went on 24, on 24/7/2025, with same sets of representation. That day again, they, my lord, accepted those representation, and my lord, they advise us to take receipt copy or, my lord, forwarding copy. They said that they will provide, and we need to collect that after 2-3 days. So thereafter, my lord, on 27 we went there, and my lord, they furnished one Xerox copy, which is annexed, my lord, in the writ petition. And lordship will find that in page number 37 and 38 of my writ petition. If lordship comes page number 37 and 38 of my writ petition, the Xerox copies which were furnished by the jail authorities here, my lord. That in the subject portion, it is written, my lord, that forwarding an application submitted by detainee Sibabuya. This one is the, my lord, letter. So, my lord, it is admitted fact that on 24 we submitted, and on 27, my lord, they communicated this letter to the respondent number 2. Now, my lord, lordship will come, my lord, that I was produced on 20. Then on 29/7/2025, advisory board confirmed the detention for 1 year. On 29.
Page?
Page is that, my lord, they have filed affidavit. In that affidavit, they have annexed the order filed by respondent number 2. Affidavit in opposition, respondent number 2. August 2025, page number 58 of the affidavit in opposition filed by the respondent number 2. Yes, my lord. On 4th August 2025, the order was confirmed by the advisory, confirmed by the respondent number 2, my
You
lord.
said 29/7?
Yes, 29/7/2025. the hereby confirm the retention order so and so passed by Secretary, Government of Assam, Home and Political Department, Dispur.
What is 29-7?
29/7, my lord, the advisory board confirmed the order.
Report on.
And 4th August?
4th August is the, my lord, order which was confirmed in my lord after the advisory board, based on advisory board, they have issued this order by respondent number 2, my lord. And this has been placed before your lordship through this affidavit in opposition. So, my lord, after 4th August, though they have submitted this order before this honorable court through this affidavit in opposition, my lord, but till today, my lord, no confirmation order has been furnished to the detainee till date, my lord, nor I have received, my lord, that confirmation order from the government, my lord. Nor the advisory board's order. Both order, my lord, we have not received. Advisory board order and, my lord, this order. Whereas this, my lord, this comes under Article 22(4), my lord. And in the affidavit, my lord, filed by the respondent number 2, nowhere they have discussed not a single whisper regarding the delay. How, my lord, this representation which was filed on 17/6 and, my lord, 20 and 24/7, these two representations, and even the another representation on 30, my lord, 31/7, all the representations, they have not disclosed anything. Neither they have considered those representation, nor they have, my lord, placed it before the advisory board. So advisory board passed the detention order, my lord, without going through the representation of the detainee, my lord. My lord, in this regard, the relevant question, which is similar to my case, my lord, was discussed, my lord, in Ashok Jalan, Ankit Ashok Jalan case, my lord, which is discussed, my lord, in para 8 of the WBC 4639. Just a little while ago, my lord, I was reading the para 10 and 11, my lord, in that same judgment, my lord.
4639 of.
Yes, my lord, 4639 of 21. Zan Parikh,
Oh, this have.
alias Sanjay Parikh. In Zan Parikh case, my lord, will come to para 8.
I'll take an extra copy from you later on. I don't have, haven't got.
My lord, I already placed 2 copies, my lord.
Can you check? Maybe Jan Parikh or not? Oh, like that. I've checked it once. Let me see.
No, go ahead, go. File with it. Got it. Okay, we have read this.
Yes, my lord, the relevant question, may I read, my lord?
Yeah, we have read this, that paragraph that has been quoted in Jan Parikh.
Yes, my lord. So same question also says similar, my lord, similar to this case, my lord. That whether the detaining authority was justified in deferring the consideration of representation till the receipt of the opinion of the central board, and whether the detaining authority ought to have considered the representation independently and without waiting for the report of the Central Advisory Board. So here in this case, what happened, my lord? First, they did not produce any representation before the advisory board. Then, my lord, they were waiting for the advisory board's order, which was passed on 29th. Thereafter, they passed their order on 4th August. Whereas they have mentioned, my lord, that they have received that representation on 13/8. But my lord, the same respondents
13
contradicted 13/8.
after a confirmation order.
Yes, my lord. So contradiction part, my lord, in affidavit filed by 2, they have mentioned that it was received on 13, and my lord, it was representation received on 13, and my lord, on 4th August, they have confirmed the order, and on 29/7, they have received the confirmation order given by advisory board. But in respondent number 7's affidavit, my lord will find that even in the annexure, my lord, I have annexed here, that page number 37 and 38, that letter, forwarding letter, is clearly shows that it was sent in 27, my lord, on 27. If it is sent on to 27/7/2025, in one place they have given this forwarding paper, and in another place, my lord, in another affidavit, they have shown that they have categorically mentioned that it was received on 13. So there was clear gap, my lord. My basic humble submission is that, my lord, this gap was not nowhere mentioned, no whisper, on total silence, my lord, on this regard, and delay part was not nowhere, my lord, they described, my lord. They have-
What are the dates in your case? Give the dates. Because here in the pre-questions posed by the court,
Yes,
the delay was from 27/11/19 to 14/1/2020.
yes.
What are your dates?
My lord, in my case, lordship will note,
Give
my
the
lord,
dates.
yes, from the very first beginning, my lord, order was passed on 5/6/2025.
Yes.
Then, my lord, it was communicated to detainee on 11/6/2025.
Yes.
Then, my lord, first representation I submitted on 17/6/2025. Before the respondent number 7.
Yes.
That was the first representation. Then on after 17, my lord, again I submitted one representation on 27/2025.
27?
20.
27. Okay.
27/2025. Then, my lord, on 24/7/2025, again I had to submit, because, my lord, on 20 they advised us to come after 2-3 days later, my lord. Then on 27/2025, 27/7/2025, they communicated us a Xerox copy of the forwarding letter,
Which
You-
forwarding letter?
which is annexed in my writ petition, page number 37/38.
Forwarding letter of which, what forwarding?
Forwarding letter of representation, my lord, that respondent number 7 forwarded this representation to the respondent number 2, that is Home and Political Department, Government of Assam, my lord.
Yes.
Yes. After 27, my lord, 29/7,
Yes.
29/7, my lord, advisory board confirmed the detention order, which was passed on 5/6/2025.
Report of advisory board.
Yes, confirmation order, my lord. Confirmation.
Confirmation order is 17/4/8.
No, confirmation, that is, my lord, given by government, not advisory board.
Advisory board will give a report.
Yes, that report was,
The confirmation order has to be conveyed by the government.
yes, my lord. Yes.
Government.
Yes, yes. So sorry, madam. A confirmation
Confirmed.
report,
Report is your.
29/7.
Board is 29/7.
Right.
Confirmation order is 4/8.
4A. In the meantime, my lord, after 29/7, the detainee's mother, my lord, sent another 2 representation by speed post, my lord.
29/7.
No, 31/7.
31/7.
Yes. Thereafter, my lord, comes 4/8, that is the confirmation order by the government, my lord.
Yes.
These are the dates, my lord. Now, another date which they have mentioned, that is, my lord, 13/8/2025. They have received the representation. They have admitted, my lord, they have received that representation.
Of the
on-
mother.
Yes, my lord, on 13/8.
Yeah.
So my humble submission is that, my lord, since even if, my lord, from the 17/6/2025 to till date, my lord, no representation is considered by the government as well as by advisory board also, my lord.
What about the representation of 27 and 24/7?
24/7.
Yes,
It
They-
was accepted by the superintendent of jail
yes.
and they handed us, handed over a forwarded letter, my lord, which I have enclosed.
So
Next-
those representations have not been considered.
No, my lord, we submitted addressing the respondent number 2 and advisory board, that is respondent number 4.
Yes.
They communicated this representation to the authority, my lord. And that communication,
The advisory board acted on which papers?
that was not produced before the advisory board by the government, my lord. That is our,
No, the advisory board had on record, it appears that the advisory board has taken a decision on 29/7/2025.
yes,
On the basis of what?
basis of, my lord, on 20. On 20, I was produced before them, my lord, without representation. So my humble submission is that, my lord, both, my lord, both advisory board as well as,
27 and 24/7, there were representation. Whom you have addressed to, will it matter or whether your representation has been considered by the appropriate authority is more important?
my lord, the question is that, my lord, there was extreme urgency. They had to show, my lord, the urgency to send this representation as early as possible to the respondent number 2, which they were failed. Number 1. Number 2, my lord, without producing documents, that is representation, my lord. Before the advisory board, they should not produce me before advisory board, my lord, without considering their representation. First, they had to consider my representation. Even till today, my lord, they have not considered my representation. That is the vital,
We'll hear
part.
Mr. Goswami, we'll see the records also.
my lord, my lord.
Anything else?
My lord, in this regard, my lord, in this point, my lord, I have some citations. I will submit.
So just before you close in this round, that means are you saying that when the advisory board gave the confirmation opinion, the representations of the petitioner were not before the advisory?
No, my lord, not before advisory board as well as government also till then, my lord, not considered. And one more important aspect, my lord, that is constitutional provisions, my lord, under Article 22, that, my lord, till today, detainee has not received any confirmation order till today. Neither advisory board's order nor government's order. That whereas, my lord, order, detention order and subsequent orders, all orders should be furnished to the detainee. That is constitutional mandate, my lord. My lord, regarding delay part, my lord, which is not at all explained in the affidavit or anywhere else, my lord.
Which delay?
Delay of consideration of representation, my lord. I am relying, my lord, one apex court judgment, Rasid Kapadia, my lord, 2012, 11 SCC 745. My lord, will come to Rasid Kapadia versus Medha Gadgil. 2012, 11 SCC 745.
Is there?
Just a minute. No, just a minute. Yes, Mr.
My lord,
Anything,
that judgment, my lord.
which judgment?
Rashid Kapadia, my lord, Megha Gadgil. 2012-11 SCC 745.
Yes.
Para 13, my lord.
Yes.
May I read, my lord? Para 13.
Slide. Proceed. Just a minute.
Rashid Kapadia versus Megha Gadgil, 2012-11 SCC 745.
লাষ্টৰখন কি লাষ্টৰখন? সেইটো বেলেগ ন? ঠাণ্ডা এইটো নহয় এইখিনি নহয় এই লাষ্টৰটো কথা আছে মই চোৱাখিনি চাই Yeah. And এইটো উল্টাকে আছে এইটো উল্টাকে আছে Yes.
My lord, Para 13. It is well settled that the right of a person who is preventively detained to make a representation and have it considered by the authority concerned as expeditiously as possible is a constitutional right under Article 22(5). Any unreasonable and unexplained delay in considering the representation is held to be fatal to the continued detention of the detainee. The proposition
Which
is
para are you
to,
referring to?
13,
Malad 13.
1 through.
Should I read again, Malad?
No, you keep reading.
Any unreasonable and unexplained delay in considering the representation is held to be fatal to the continued detention of the detainee. The proposition is too well settled in a long line of decisions of this court. We do not think it necessary to examine the authorities on this aspect except to note a couple of judgments where the principle is discussed in detail. They are Mohinuddin versus District Magistrate Beat and Harshala Santosh Patil versus State of Maharashtra. So, my lord, again, two judgments I am relying, my lord. Sushant Kumar Bonik, which was earlier Lordship has seen, in that judgment, my lord, para 20, that Sushant Kumar Bonik judgment, my lord. And in Rasid Kapadia, it is para 13. My lord,
Yes.
Sushant Kumar Bonik, my lord, it
Yes.
was clearly written, my lord, that it is manifestly clear from a conspectus of the above decision of this court that the underlying principle is that if there is unreasonable delay between the date of order of detention and actual arrest of detainee, and in the same manner from the date of proposal and passing of the order of detention, such delay, unless satisfactorily explained, throws a considerable doubt on the genuineness of the requisite subjective satisfaction of the detaining authority in passing the detention order, and consequently render the detention order bad and invalid, because the life and proximate link between the grounds of detention and the purpose of detention is snapped in arresting the detainee. A question whether the delay is unreasonable and stands unexplained depends on the facts and circumstances of each cases. Madam, regarding life and proximity link, Lordship asked before Lance, madam, that what actually like proximate link is connected to in my case, madam. The detention order must be based on recent and relevant conduct of the accused, my lord. Conduct of the detainee, my lord. If the Ellis activity is too old or there is a long delay in issuing the detention order, the connection between the activity and the need of the need to detain is considered is stale, my lord. The word is used by the apex court, my lord. So that is all, my lord.
Yes, Mr.
May it please your lordship. Well, the first thing, as he has referred to, my lord, the representation that's at 307/2025 that was received by the government 13/8/2025. After the confirmation of the detention order. Actually, certain aspect I am clearing.
No, this date, we have not understood which representation?
His representation,
Dated?
30.
Not 30. He said representation is 27 is there.
No,
27 and 24/7.
307/2025.
37, there is no representation we find.
31/7.
No, 31/7 is my
30
mother. 31/7.
307/2025.
Is it 31 or 30?
31, my lord. That is their mistake, my lord, that no
In
representation.
any case, my lord, that is the representation received by the government, my lord, on 13 August.
30,
30
yes,
August.
yes.
I am clarifying, my lord. And so far furnishing of documents are concerned, my lord, that is there in the record, my lord. It was duly received by the petitioner. All detention order, all these things, all these things were furnished to him, my lord. And accordingly, he received this. And I'm told that at one point of time, my learned friend even submitted before this honorable court that advisory committee did not take any decision. That also there. So, my lord. So it is not correct to say that detention order and the connected documents were not.
When was
furnished,
this writ petition presented?
My lord,
When was this writ petition presented?
19, I think. First,
Filed on 20th
It
of
was filed on
Huh?
28,
28, order prosecuted.
2008.
Oh.
And firstly,
And took
listed
up the
on-
matter by this honorable court on 19.
19.
That is okay. Filing is dated 28.
My,
And advisory board report is 29/7.
yes. And in the representation as well as in the statement made before the advisory committee, my lord,
Yes.
the petitioner or the mother of the petitioner never raised the issue of that he now says, my lord, all the documents were ineligible. These things never raised, my lord.
Well, I'm just adding to what we have also, we have also noted that there are two representations,
My lord, one,
27 and 24/7, which has stated, even
Right.
31/7. In those representation, this point has not been taken.
Hmm.
Have you taken this point?
no,
My lord,
Illegible document given to you in your representation.
no, my lord, it, in. My lord,
If you have taken, kindly show it to us.
even he did not raise the issue before the
My
advisory
lord.
committee when he was
No, these
heard.
are factual matters. These are not law matters.
Yes,
My lord, and
If
let-
you have given illegible documents, you have to say it to the authorities.
My lord, that respondent number 7, they are they were the executing authority. As a, my lord, when they executed this order upon us, my lord, our first duty, our first authority was my respondent 7. We asked them, my lord, to make us understand in Assamese language.
No,
to
where
give
is
us,
it, where is it in the representation?
my lord,
In the representation, have you stated?
my lord, in representation, I have.
That is the first point which you have for being aggrieved. You may not be very elaborate, but you must say that copies given are not, we do not understand. Copies are not legible. These are all factual matters. These are not matters of law that you need to be know what are the legal provisions. These are
point is, my
some
lord,
papers have been given which are not even readable.
My
You
lord.
give it.
Only
You have
thing,
not
my lord,
stated.
principles of natural justice has been complied or not, my lord.
You have not
Yes,
stated.
exactly, my lord. Principle of natural justice were complied or not, my lord. In that regard, law is well
Sufficient.
settled, very clear that, my lord, it is not a question for demanding papers, my lord.
You are
Demanding,
not required to demand. Where have you stated? It is not a question
the
that on demand you
representation-
have not demanded, so not given. You said given but eligible, illegible.
Yes.
In the writ petition you have stated.
yes.
In your representation, have you even made a reference, passing mark, passing reference?
My lord, we referred these things, my lord, in our writ petition as well as in the,
No, writ petition you come much late.
just a minute, my lord. I am checking.
It may be there. Please check and tell us.
At least they could have mentioned before
No,
the,
otherwise, my lord, no doubt I am checking it. Otherwise, it may not be ground, my lord, because the law is very clear that, my lord, in a preventive detention case, my
The
lord.
law
there
is
no
clear, but
question
there is a denial that illegible papers have been given to you. It is not admitted.
My lord, I understand. Then, my lord,
If
then-
even if we have gone, if in the first date, when you had gone, some copies not readable, you tell them this, what is this?
even before submission of the
You give
representation.
elaborate representation of 3 pages, you don't even mention this.
Because I,
So to accept that there will be some difficulty, we have to take it with a pinch of salt.
According to the
Whether-
authority.
He should have first
copies were
approached.
submitted. Sorry,
yes.
according to the authority, the legible copies were submitted. That is what
That is
stated.
there, and my lord, at no point of
Denied.
time, it was not, there is no objection on the part of the petitioner or the representative of the petitioner.
My lord, the question is that, my lord, lordship is asking about the representation, my lord. How I will write representation where illegible copies is there, where, my lord, that no record, incomplete record. So, my lord, in general, what I know, my lord, what I
Some
have
copies
faced,
have been given to you which are not readable. You don't even mention it in the representation.
my lord, that is.
This kind of illogical things, kindly do not make submissions on this.
Even before
These are not
submission,
required to be put in law.
yes,
Suppose in a suit, you take the plea that the suit is not maintainable. If you don't take it in the first day, it will be barred.
Even
And these are
before-
basic things. I
Yes.
don't understand what is the detention about. Please make me understand. What is this kind of copies? I don't, it's not readable. State it. If it's the first day you not raise, in 2000, in August 2025, when you present this writ petition, you raise this.
কেতিয়া দিছে?
Maybe it's okay, you are still permitted. When it is denied on facts and your verification is not proper.
Then, my lord, one another question related to this matter submission. Suppose,
You will come to yes, Mr. Goswami,
Yes.
finish your. You
So
come-
even before submission of his representation, my lord, he ought to have approached the authority seeking clear documents, my lord.
No,
If
that
was the
that
case,
is not required.
my lord. No,
No,
if
no,
anything is
no,
there-
that would be
Yes,
required.
that is
That
not
would be required if he raises the issue that illegible copies have been given to me.
My lord.
That he has not even raised.
Yes,
But demanding of documents is not necessary. It has,
Yes.
it's your burden.
yes.
You have to
My-
give him all
our
el-
burden, my lord.
all legible
If-
copies.
If any objection is there, my lord,
Yes.
if any objection is there on this aspect, my lord,
Yes.
he could have approached the authority, my lord. Lordship, my respectful submission is, my lord, it's a subjective satisfaction of the detaining authority, my lord. So if there is any irregularity,
This one.
এই প্যারাগ্রাফ 18 যে কইছিল না না প্যারাগ্রাফ 18 যে আসলে কি বুঝতে পারছেন ওই তো But once again, my lord, can I read the ground of detention, my lord?
Page,
Page 18, annexure 2. According to the writ petitioner, my lord, he is no way connected and to apprehend him in any manner, my lord, there was no basis, my lord. That was the basic thing he raised, as I understand, my lord. Lordship will kindly see. You were born so and so, my lord, your son. Second, it is confidentially learned that you started illegal trafficking of narcotic and psychotropic drugs as drugs peddler for last several years. Further, you were associated with various other cases. You were involved in Biswanath Saili Police Station case number so and Jinjia Police Station case number so under NDPS Act. The district police has registered 2 numbers of cases under NDPS Act, and during investigation, it was found you were involved in the business of drugs. It appears from the record that on 6/1/2022, at 8 a.m., information received regarding illegal selling of drugs by you, Sibo Bhuya, and alias Sujal Bhuya, at Ammari, Biswanath. The police conducted search operation in presence of witness. During the search, police recovered 6 grams of heroin from the possession of Sri Pankaj Gupta, son of Ramesh Gupta, village so-and-so. During interrogation, the said accused has stated that the above heroin was purchased from you and your accomplice. In that case, this was first case, my lord. In that case, search sheet has already been submitted, my lord. First case. During the pendency of that case, your lordship will kindly have a look at next paragraph. Further,
Yes.
on 31/5/2024, at about 1:30 a.m., information received that 2 individuals, you, their name there, and your accomplice compelled a minor boy, Shivam Sundi, son of so-and-so, a class 10 student at Monabari High School, to engage in drugs trafficking at Monabari under Jinjia PS. The police conducted search operation in the house of Sivam Sundi at Monabari, and during search, the said minor board willingly produced the NDPS items, which were 29 plastic vials containing heroin 36 grams. The minor boy was compelled to conceal the NDPS item in the house by you and your accomplice. During the investigation, you were arrested, and after proper interrogation, it was found that you and other individuals were operating illegal drugs business in the Biswanath Sariali area. This refers Biswanath Sariali police case number so-and-so. The case here has been referred to, my lord. Then paragraph 4, from the above cases, it is evident that you have involved. The first, my lord, search sheet was submitted on 18th, in the first case, 18/3/2022. And next case, my lord, on 31/8/2024. My lord, here is not a case that there was enmity in between police and the petitioner, my lord. So the petitioner has not made out any case that to fulfill grudge on the part of the police, all these things were done. From it is evident that you are you have involved yourself in the crime of illegal trafficking of drugs in Biswanath district. You are engaged in illicit drugs trade, turning a large number of youth into addicts, harming not only their health and future, but also depriving the nation of quality human resources. This has detrimental effect on society at large and encourages addicts to engage in criminal activities. Further, you are bound to be habitual offender of such illegal drugs trafficking in violation of so-and-so, despite your arrest.
You're not bound, found.
Sorry, you are found.
Found.
Sorry.
Bound will be different.
Bound will be- Sorry, you are found to be habitual offender so-and-so. Other cases are also there. I'm not mentioning all these things, but in the record that is also there. Despite your arrest in different cases, you have neither mended your ways nor shown any remorse for your criminal acts, and you continue to engage in criminal activities with the help of your accomplices. At present, you are out of bail. Your release appears to be seriously detrimental to society, as there is a high likelihood of you resuming illegal drugs activities in the Biswanath district. You are one of the main conduits through whom drugs were supplied, thereby violating the provisions of so-and-so act. Your detention is necessary to deter other criminals to protect the younger generation from the meaning of drugs in Biswanath district. It is therefore considered essential to prevent you from engaging in activities prejudicial to the provision of NDPS Act 1980 by detaining you under the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substance Act 1988. You are, however, informed that you have the right to make a representation and may submit your representation against the order of detention through the concerned jail authority, if so desired. So, my lord, my respectful submission in this regard is a preventive measure, my lord. And my lord.
And page 20 is also, the next page is also there.
Yes, my
To
lord.
whom the representation has to be given.
Yes. Nothing is left, my lord. And during the pendency of one case, again he committed next, my lord. So, as your lordship knows, my lord, the present trend, my lord, even in Guwahati, how this dangerous business is going on, my lord. So, with a view to stop all this illicit, my lord, business, my lord, state has taken certain action. Even then, we must say the state is also presently not in a position to stop all these things. my
No,
lord.
no, we are not on your policy.
My lord.
We are on the aspect of following the law,
Yes,
procedure.
certainly. My lord,
prescription
only
of
thing
law.
is, my respectful submission is, record is there, my lord.
Hmm.
Whether there is any irregularity on the part of the authority. Otherwise, it's a absolutely, my lord, subjective satisfaction of the detaining authority, my lord.
So you-
And the basis on which the basis on which action was initiated, my lord, as I have shown, my lord, before lordship, my lord. This is the background, my lord. And with this background, authority proceeded, my lord, for the betterment of the society. So even then, if there is any irregularity, my lord, certainly lordship will examine all these things, my lord. But my respectful submission, my lord, absolutely it's a subjective satisfaction only on the basis of the examination, only after examination of the record, honorable court may consider all aspects of the matter. my lord.
The basic power of the exercising the preventive detention.
Yes,
Under the PET and DPS Act
Yes.
comes from section 3,
my lord.
section 3 of the act,
Yes,
right?
sir.
Can we have a look at this? Just for
3(1).
recapitulation. 3. With a view to preventing him from
Yes.
engaging in illicit traffic.
Yes.
That is the basic
Yes,
objective,
that is the basic.
to prevent him.
Yes.
So, in a way, as I understand, subject to correction is that, in this case, we have to see this thing that the last case was in 24, mid 24, right?
My-
So whether the proximate test, as he has indicated, whether the proximate test is fulfilled, number one. Number two, whether there is any procedural infirmity.
Yes, that's right. Nothing else, my lord. Otherwise, it's a subjective satisfaction. my lord. If procedural, there is any lapse, my lord, that can be examined
Yes.
after going through the records are before lordship, my lord. Lordship may examine it. And my limited submission, my lord.
Very
Any-
good, Lordship.
ৰ'বা মোক কৈ ল'বলৈ দিয়া ইমান উৎসৱ কিয় লগাইছে ঠিকে আছে নি তুমি পঢ়া নাই ঠিকে আছে তো এইটো পাইছো এইটো ইয়াত লগোৱা নাই নেকি এইটো ইয়াৰ নাই এইটো 22 এইটোৱেই হয় Found it. Maybe I did learn over here. It's it. Two judges only referring to my, this is my limited submission, my lord.
What is this?
Two submission, my lord. Para 22, my lord.
2017?
2012, two SCC.
389.
No, one SCC, 5.
One is, oh,
You have given two.
17, one SCC, right?
757.
Yes. Please.
Is
And another one is, my lord,
Subbulakshmi.
yes. Another one is 2012 USCC 389.
You have given one copy of one judgment to one of the judges and one copy to other judge. Distributive justice. This technique we have not found. It amounts to giving both the judgments.
Sorry, my lord. Extremely sorry.
It's okay.
What has been said in East
No.
Subbulakshmi?
Oh,
You don't have a copy.
22.
One is it? There are 22.
So that was a wise move. satisfied the judges by 2 copies, one of each judgment,
Well,
as well as have a copies with you also. So you take back your copies.
okay, there are some.
All give and take.
No, we'll furnish the copy.
No, at least make your submissions from the.
Yes,
copies.
yes.
In Subulakshmi, what is, I don't know. What is Subulakshmi? Paragraph?
One is paragraph at তিনটা নিয়ে নেবেন, 15, my lord. Paragraph.
1-5.
Yes, ma'am. From the plain language of the so-and-so, seen that the state government order is an order issued by the state authorizing or delegating power to the Commission of Police. And so the question is whether it is mandatory for the detaining authority to supply a copy of this government order. The order, even in respect of supply of copy also, the order having been issued in exercise of power so-and-so, being a statutory order has nothing to do with the grounds of detention. What is imperative is to supply all documents which are relied upon by the detaining authority for forming subjective satisfaction for the purpose of Article 225 of the Constitution. The government order, however, is regarding the delegation of power to the Commission censor. This must only be. And another one, 22. In a matter of detention, the law is clear that as far as subjective satisfaction is concerned, it should either be reflected in the detention order or in the affidavit justifying the detention order. Once the detaining authority is subjectively satisfied about the various offenses leveled against the detainee, habituality in continuing the same, difficult to control him under the normal circumstances, he is free to pass an appropriate order under section 3 of the so-and-so by fulfilling the conditions stated therein. We have already concluded there is no infirmity either, so-and-so. This is the matter. And it is abundantly clear, my lord, in the present society, my lord, youth are engaged, juvenile are engaged, and here there is a glaring example. My lord. So this is my only respect to submission.
Please explain the records.
Yes. Well, it is.
Huh?
The
You have a
copy.
copy, yes, please what the question.
Mr. Rahman, you mentioned about one of the representations being forwarded
Yes, madam.
subsequently. Which was that?
That in my writ petition is page number 3738, madam.
Because in the advisory board's opinion,
Yes.
it is mentioned that no representations were placed before.
Yes, exactly, madam. That is what I was making submission on this point.
Where
Not faithful, he is not.
he has not filed,
He has not filed, not
Yes.
willing to file.
not filling to file.
It was not communicated by the exile authority to the authority, madam. That is our ground actually, madam.
Date of birth, date of birth.
Lisa.
It will be 27/7.
The representation.
There was
File your representation.
27/7.
Madam,
Oh, excellent.
madam, regarding submissions made by my senior colleague, madam,
Just a minute, we have not. What is the date of your representation?
first one is madam 17/6,
Where do you
2020.
get?
Madam,
Where do you get?
madam,
Where is it written?
in the writ petition, madam, it is
Not in the representation.
Have
in
you
the
had
writ
it?
petition I have annexed, madam. The first representation, then
Yes. Where?
yes, in the page number, madam. Question. Page number 30 and 31, madam.
31, you have not given the date. Why?
it's 29 and 30, my lord. Sorry, 29 and 30.
17.6.
Then 31, my lord is asking about date.
Yes.
Yes, my lord, this was a representation I submitted to the jail authority. The jail authority said that don't put the dates. We will first we will talk with our authority, my lord, then thereafter we'll communicate to you. This was a 20. Then on 24.
17.6.
My lord, this submission will be clarified by their own records, my lord, which was communicated to us. That is 37 and 38.
It was forwarded by the jail authority on 27 July,
Yes, my lord. That is why I'm,
after
No,
the advisory opinion.
No, just, Mr. Roman, some clarification.
yes, my lord.
Come to page 29.
29.
Yes.
Yes, my lord.
29 is a type copy of 30, isn't it?
Yes, my lord.
Okay. This is by whom? This is by your mother.
Mamoni, right.
Okay.
Right.
Then at page 31,
Yes,
these are type copies. Where we would like to see, have your original copies?
No, madam. How can I, this was the representation, my lord, first, that representation on 17.6. Thereafter, my lord, because I was
We are
I was
not on-
settled from
not
here
on-
and
not
there,
on- Not on those aspects, not on merits. We are on the presentation of this petition.
my lord.
This is a type copy where your signature has to be there. Where is that copy? Would
My
like to,
My lord, I categorically mentioned in my affidavit, why start date and signature is not there, because my lord, we had to give the draft copy to the jail authority, my lord. Jail authority
no,
was,
yours faithfully, your name is there.
no, my lord, they have not provided us that receipt copy. That is the problem, no, my lord. That is what I'm making submission, and in this regard, my lord, if any doubt is there, my lord, then that doubt will be cleared by the page number 37 and 38, my lord. We gave them copy, that is the proof that they have given us the forwarding Xerox copy, my lord.
See, to forward an application
Yes.
by the retinue, it has to be signed by you.
I understand, my lord. But our problem is that,
Without
my
the
lord,
signature, can it be forwarded? We
Right,
wanted
my
to
lord.
have a look at the original copy. These are typed out for the purpose of presenting before the court. Page
But-
30, 31 and 34.
my lord, if it is true, then my lord, how they gave us these two copy, my lord, 37 and 38? Because we gave them copy. That is the evidence, my lord, the admitted fact, my lord.
এরকম original থেকে এরকম input করে এরকম। Page 31 and 34.
We gave them copy. That is why they, after 3-4 days, they have given us that Xerox copy, my lord.
Repetition.
But regarding one aspect that lordship were asking, that whether I have mentioned this in my representation or not. Before,
No, we are not on that. We are on this copies 31 and 34. Last page is fine. No, statistics about it. Type করে দিয়ে দিতে। এরকম করবো না। কিন্তু photo ওখানে দেখতে পাচ্ছি না।
The original did not have signature. It was submitted without signature and date. by
yes,
the
my
jail
lord.
authority.
Yes, my lord. As I
According
have,
to you, as
yes,
per their direction.
yes, as I have mentioned in my oral submission and in my written also, my lord, that when we went there on 27, they instructed us that today morning only the detainee has been taken to Guwahati. So you come after 3-4 days and you
Let
give
us
us
see-
the draft copy.
let-
We will put signature and we'll forward it.
Let us see the, let us see the amendments. Page 8,
Page 8 of,
your read petition.
yes, my lord. My lord, regarding illegible copy and incomplete relied documents, lordship was asking me to show in the.
Please don't divert the issue, Mr. Rahman. We
My
will
lord,
answer that.
Sorry, my lord.
First,
sorry.
you come to what we are trying to understand from you.
My lord.
Page 8.
Page 8 of my petition,
Yes.
my lord.
Page 8, please read. Please read.
From the first, my lord,
Yes, yes.
it is evident
These are
from,
nothing, you have not said anything like this.
it is evident from both the above cases that the instant detainee was never ever involved with such offences under NDPS
No,
Act.
no, paragraph 5, page 8, paragraph 5.
Paragraph 5, that the petitioner detainee begs to state that as per advice of the Deputy Superintendent of Police DSP Biswanath, the mother of detainee submitted a representation on 17/6/2025 before the respondent number 7.
Yes, that is there. Okay, then.
Yes, unfortunately, no responses were given, no response was given from their end.
Hmm.
And they did not even provide a receipt copy of the representation to the mother of the detainee.
Hmm.
Therefore, having no other option, the mother of the detainee submitted an application in the name of the detainee before the respondent number 8, that is Superintendent of District Jail Biswanath, on 24/7/2025. But surprisingly, they refused to provide any receipt copy and ignored the family members visited jail, for which, having no other option, the mother of the detainee again sent one representation by registered post on 31/7 addressing the respondent number 2 and 4.
Hmm.
Surprisingly, on 6/8/2025, the officials of the respondent number 8, that is the Superintendent Jail Biswanath, informed the family member, family of the detainee, that the family of the detainee can collect a photocopy of the forwarding copy, which was submitted on 27/2025 before the Superintendent of Jail Biswanath. In the said photocopy of the representation, the date is shown as 27/2025, which is put by the Superintendent of District Jail Biswanath. The authority has not disposed of the representation on time, and the inordinate delay is intentional, and the authority is failed to explain anything regarding the delay in disposal of the representation.
So where are your averments which you are now trying to convey orally,
My lord,
that you had given representation without any signature, without date, and those were forwarded by them?
No.
Where are those?
my lord, those
Those are
are,
very, very significant facts
those are,
in determination of this issue.
those are annexed here with this petition, my lord.
No, no, where are the averments?
Averments related to, my lord,
That you have given unsigned copy, unsigned representation, which were forwarded to them, and these copies which were enclosed to the writ petition were the same copies which does not bear a date. They had asked you not to give
No,
you a
but
date.
just because averments is not there in the para,
Then
my lord.
how do you come to a conclusion? They
Then
had
my-
oral argument
Then, my lord, I
in a
have,
writ petition.
and then, my lord, I have a, my lord, submission that how page number 37 and
We are not
38
here
was-
to give you answer to your question.
Understand, my lord.
You are making an oral submission that they had asked you to give representation without a date. That is your oral submission. These are matters which will form a basis of the opinion which will be rendering.
My lord,
Where is it
my lord will
in
come
the
to
writ petition?
page number 37.
We are not on the enclosures.
No, my lord, they have written this. Forwarding an application, submit my detail. That means I have submitted that representation, my lord.
That is exactly what we are asking. Where is the date? Which date did you give? Page 31 and 34.
That date is not in
is
the
not
representation,
crucial
because, my
because-
lord, they instructed us to give.
Where is it? Where have you stated?
No, my lord,
These are very, very crucial things.
my
You
lord.
give on a date, then after 10 days, 12 days, they give they make a delay. We don't even know. It might have been forwarded on the same date.
Just one date is missing because, my lord, they, as per their instruction, we submitted. But the later subsequent representations are very much mentioned, my lord. Date is mentioned. Even the first one, 17/6, and the last one, 31/6, 31/7, my lord.
By that time, the advisory report committee has already given the report.
I understand, my lord.
Advisory committee report is of which date?
If it is so, my lord, then till today, my lord.
29/7.
29/7.
Yes, if it is so, my lord, then it is their constitutional,
27.
207.
my lord, it is.
Yes. On a 20. Yes.
So Rahman, actually, see, the forwarding by the jail authority is on 27 July. right?
Yes,
And the opinion is dated. That means it was forwarded after the opinion had already been given. And it was recorded that no representation on record. Therefore, this date is important, and therefore that averment is important.
My
That
lord-
I submitted without date. I was asked or whatever to submit without date.
my
Right?
lord, my lord
Your
will,
point.
my lord will notice one thing. On 27/7, that representation was forwarded. Just after 2 days, it was confirmed. My lord, now question is that, my lord, this representation, why they they were waiting since 17/6/2025. Where is their explanation regarding the delay, my lord? That is, my lord, vital part of this case, my lord, because they are failed to, my lord, give explanation in that regard, my lord. Regarding submission made by my senior colleague, my lord, 3 points I would raise, my lord. Number one, that, my lord, regarding illegible copy and incomplete related documents, my lord. Even my lord was asking me to show this part in my representation. And at that moment, I was unable to show this, but right now I have found it, my lord. It
Where
was
is
very
it?
much.
Where is it?
Yes, my lord, lordship will come to page number 40, my lord.
40.
40. Point number 3, my lord. From the first line, that order number so and so, dated so and so, along with grounds of arrest were furnished to me on dated 11/6/2025 in a language which is not known to me, as well as the detainee, that is my son Siba Guya, and no one explained anything while my son was taken into custody. The police person, it was my lord DSP only who executed the order, who asked instructed us to appear before him, and on that same day, my lord, I was taken into detention, my lord. So the next line, the police personnel who furnished the order and grounds of arrest were unable to explain for which my son was detained under preventive detention law. Therefore, as per advice of DSP, we approached the superintendent of police Biswanath by way of filing a representation. Unfortunately, the office of the superintendent of police Biswanath did not even provide us a receipt copy. So and so, my lord. So this was very much clear, my lord, that those documents with illegible copy was there, then incomplete related documents were there. My lord, one more submission.
Yes, yes, which part again? Which part? Page 39.
40.
40, yes.
Para 3,
Illegible, where is illegible?
Para 3, my lord.
Para 3, yes. Where is illegible?
In a language which is not known to me.
And illegible documents?
My lord, regarding illegible documents, the word is not there, but my lord will see the entire thing. My lord, being a illiterate lady, my lord, a class 10 pass boy, my lord, who is age of 27 years, I will, my lord, know the details that whether these documents are complete or incomplete, whether these documents are legible or
Mr. Rahman, Mr. You should not be too crafty in the court. Please maintain your simplicity.
my lord.
It's the same, it's a
A
different.
10 pass person will not know whether a document is legible or illegible.
My lord, those documents were illegible.
Is it required to even be illiterate?
No, my lord, those documents are illegible.
Where
That
is it
is-
stated?
That is even, my lord,
From
there are
from a
documents which
reading
show,
of
my
the entire document, we'll know that it is illegible. Where is the statement? Illegible documents given.
my lord, I have categorically mentioned in my
It's not there,
petition,
it's
not
not
in the
there.
representation.
Fact is
If
fact.
it's
The
not
word
there,
is
it's
missing.
not there. If it's
My
not
lord,
there.
the word is missing in the representation, but entire story is there, my lord. How I was
Then
explained,
we can assume many things.
my lord.
They can also say, now many things were explained to you.
My lord, regarding this, the report is available,
not an
original
assumption,
report.
it's
On
not
last
an-
day, last
It
day,
is not an
lordship,
assumption. It is not an assumption. These are very, very important aspects.
but lordship will verify these documents whether illegible or legible in their original records, my lord.
First representation,
first-
there is no mention.
Acknowledgement was taken, my lord, from my
No mention.
mother and me, my lord.
Mother's representation is signed,
Signed, my
signed
lord.
and dated,
Signed, my lord.
signed and dated.
Yes, my lord. But that aspects shall have to be considered. Otherwise, my lord, how? Because my lord, their authority was instructed us. We had no option, my lord, but to listen them, my lord. But regarding this submission, my lord, one another aspect, my lord.
Just
We have to continue. My brother has a single bench. Mr. Goswami. If we have, we have already completed. We
Yes,
can
yes.
close it. You can, 5 minutes, you may conclude, Mr. Rahman.
Yes, my lord, my last humble submission, my lord, regarding 2 points. Number one, my lord, that, my lord, regarding delay part, they are still, till now, my lord, my learned senior colleague is not mentioning anything regarding delay part, my lord. So delay is not explained, my lord, which is a vital, my lord, ground here in this case, my lord. And regarding FIR, he has cited one judgment, even in that judgment also, my lord, that it was saying about imperative my lord, talk about relied documents. So here in this case, my lord, relied documents is missing, my lord. Both in my first case of that was perhaps Zinzia PS case, my lord, the document is missing. And in regard,
No,
my
we are
lord,
not on the
statement,
merit- We are not on the merits of those cases. Those will not express any opinion.
yes, my lord, then
You may have
relied.
a good case in that for acquittal, or you may have a bad case. We will not say anything.
My lord, my this part is only part that, my lord, the statement made by co-accused, prime accused, that is missing in this case, my lord. Even perhaps it is in the record, and my lord can check those records, my lord. And regarding delay, my lord, again I would submit, my lord, the delay part is missing in this case. Delay is not explained.
But that's those you have said.
My lord, I am for a response number 3, just 1 2 line, my lord.
Yes.
Here,
Who is free?
For a response number 3, my
Who
lord.
is free?
Union of India, my lord. Here, all proceeding has been done by the state government. He has not filed any representation to me also, to the central government also. Otherwise, I have limited role. But in this case, my lord, otherwise, the motive of the this act is to prevent the accused in doing such type of activity in future. One case, 2022, he was granted bail, that was succeeded. Subsequently, again, he is involved in such type of cases in 2024. That is also succeeded. Now, on co-accused statement or not, that will be come in the trial stage, my lord. After all, in both the cases, it was succeeded. And in one case, small quantity, he is saying about section 37. Section 37 in one case is small quantity, other case is intermediate. Section 37 is not will come. Section 37 says about section 19, if a person booked under section 19, 24, 27A, and commercial quantity.
Commercial quantities.
In all the category, he is not there. So that regards is not coming, and he is on bail in both the cases, and he may involve in such type of activities because in maybe in co-accused statement. First of all, it was someone has purchased from him. In the second case, it was found seized from a boy, and he asked that boy to keep those items. In both the cases, it was succeeded, my lord. And only regarding the delay in the representation, that is up to the state government. But regarding merit, my lord, no merit in the case, except that delay, but it will be considered by your lordship. But regarding his submission, my lord, I am placing one judgment. It's before your lordship that Ali Ahmed Laskar versus State of Assam. It was from this honorable court, 2023 1 GLR, my lord, 717. Ali Ahmed Laskar.
What has been stated?
In the relevant para is, my lord, para number 18.
What has been stated?
My lord, as discussed above, the failure of the department to send a report as mandated under section 3(2) of the central government within 10 days, as well as the mandate of section 9F of the confirmation of an order under the Act of 1988 will have to effect the rendering the detention of the petitioner to be in complete violation of the mandate of law prescribed. Since the petitioner's detention is in violation to the above provisions, the same will have to be held to be expressly illegal and in violation of his constitutional rights. So, my lord, section 3(2) of PIT NDPS, within 10 days, my lord, the government had to send report to the central government, which is not sent, and my lord, that stand you will clarify, my lord. Yes, it is not sent, but he has not filed any representation to the central government. Representation is a different thing, my lord. It is constitutional mandate, my lord, that the detention authorities shall have to send report to the central government within 10 days. That is under section 3(2), my lord, of PIT NDPS, which was not done in this case.
So we have to see what are the essential requirements. And then
Whether he is
Cross check.
prejudiced or by this, don't know.
My lord, is specifically mentioned in section 2, subclause 2, my lord, 3(2) of PIT NDPS.
that's it.
Okay. Member Oman, B. Goswami AG, then KK Parasar.
For as per number 3, my lord.
That's number 3. And B. Goswami, Deputy Recorder, B. Goswami AG, who has also placed before us the records of the case. And Sri KK Parasar, Learned Counsel has appeared for the number 3. The hearing is concluded, judgment is reserved.
Okay, item number 9, interim order. Yes.
Interim order is there.
Worship, I'm praying for a date. I'm suffering the interim order.
What kind of interim order?
Lordship, status quo.
Regarding what?
The license,
The unit.
the consent to establish.
Consent to establish of the unit.
Paucity of time? Will not permit the matter to be taken up today. Full stop. List, on request, list on
5th, Lordship, person. 5th of December.
5th is a Friday,
Yes, Lordship.
5th of December. Para, interim order passed earlier to continue till the next date of work.
Deep level.
Obliged.
My lord, regarding delay, my lord, which judgments I have